presenting the cases to the board for their review in today's public hearing. Members of the public at this time, please take a minute to turn off your cell phones or other devices so they don't interrupt the meeting, so the board can consider cases without any interruption. For these public hearings, the board reviews the correspondence submitted in support of and opposition to these cases. The board also reviews correspondence and recommendations from other government agencies in preparation for the hearings. In today's hearing, staff will present the site plans, maps, photographs, and other documents that comprise the case record. At the conclusion of the staff presentation, the appellant will present his or her case to the board. After the appellant's presentation, the board will hear those wishing to speak in support of the appeal. If the appeal has opposition, the board will then hear from those parties. After the opposition presents its testimony, the appellant will have a period for rebuttal. According to the BZA rules, the appellant has 5 minutes for presentation if no opposition is present. In contested cases, the BZA rules allow 10 minutes for each side to present testimony. Should the appellant wish to provide rebuttal testimony, the appellant should reserve some portion of the originally allotted 10 minutes. At the conclusion of each hearing, the board will deliberate and then vote on the case. The board is vested with the power to act on these cases under the provisions of the Metro Zoning Code, Section 1740-180. All section numbers that we refer to today will come from the Metro Zoning Code, which applies to the entire jurisdiction of the metropolitan government. The Zoning Code was adopted by the Metro Council and became effective on January 1st, 1998. I will introduce the entire Zoning Code and make it a part of today's record. The Metro Code requires a record of these proceedings. Because BZA meetings are recorded for the Metro Nashville Network, it's imperative that anyone addressing the board come to the front table and speak into the microphone that's on that table. All speakers should identify themselves by name and address before making the desired presentation. I would also note that this particular room does not have sound amplification, so if you have a case that you're here on in support of opposition, if you need to be sure that you hear what the speaker is saying, these microphones don't amplify it around the room, so you'll want to move up to the front of the room to make sure if you can't hear. The Metro Code requires 4 members of our 7-member board to establish quorum. The code also requires at least 4 affirmative votes to grant an appeal. In the event that 5 or more members are present, but the appeal fails to receive 4 affirmative votes, the case will remain on the board's agenda for the next 30 days. Applications that fail to receive 4 affirmative votes within 30 days of the public hearing shall be deemed denied by operation of law. Pursuant to board rules, an aggrieved party may appeal board decisions to Chancery or Circuit Court within 60 days of the entry of a BZA order. Additionally, as per the BZA rules, an aggrieved party may file a motion for rehearing by the BZA within 60 days of the original hearing date. After that time elapses, the board's decision becomes final and no further action can be taken. If your appeal is granted, you're required to obtain the permit for which you applied. A permit must be obtained within 2 years for board approval to remain valid. It should also be noted that if false or misleading testimony is presented to the board, any board approval could be revoked at a later time by means of a show cause hearing before the BZA. Mr. Chairman, I submit that all cases have been filed in proper order, all appellants have been notified by certified mail, and all legal notice requirements have been fulfilled. I do have some preliminary announcements regarding deferrals and withdrawals. First, case 2019-085 has been deferred to September 15th. Case 2019-212 has been deferred indefinitely. Case 2019-265 has been withdrawn. Case 2019-300 has been deferred to September 15th. Case 2019-341 has been withdrawn. Case 2019-350 has been deferred to September 15th. Case 2019-351 has been deferred to September 15th. And case 2019-376 has been deferred to September 15th. And that is my mistake. Every September 15th I just said should be September 19th. So if you had a case that you're here for today that was deferred to September 15th, that was actually deferred to September 19th. That's case 2019-085, 2019-300, 2019-350, 351, and 376. Those have all been deferred to September 19th. Thank you for calling that to my attention. For members of the public, our board utilizes a consent agenda at each of its meetings. One board member reviews the record for each case prior to the hearing and identifies those cases which meet the criteria for the requested action by the appellant. If the reviewing board member determines that testimony in the case would not alter the material facts in any substantial way, then the case is recommended to the board for approval. We'll enter into the record those cases that have been so recommended, and if anyone is here in opposition to one of the cases identified for the consent agenda, please raise your hand, make sure I see you. We'll pull it off the consent agenda. Let's wait till we get to the consent agenda so I know what case you're here for. And make sure I see you so we can remove the case from the consent agenda. That hasn't been announced yet, so it may be that your case is not on the consent agenda. Please note that any sidewalk case placed on the consent agenda, the applicant has agreed to planning's recommendations. Mr. Chairman, these are the cases that have been recommended for the consent agenda. First, case 2019-349 involving property at 4898 Nolensville Pike. Is there anyone here in opposition to case 349? Seeing none, next case 2019-353 involving property at 1822 Cephas Street. Is there anyone here in opposition to case 353? Next, case 2019-366 involving property at 716 Crowley Drive. Is there anyone here in opposition to case 366? Seeing none, case 2019-370 involving property at 1527 Riverside Drive. Is there anyone here in opposition to case 370? Yes, so we'll pull that one from the consent agenda and hear it in its regular order. Case 2019-371 involving property at 1240A Thomas Street. Is there anyone here in opposition to case 371? Seeing none, next case 2019-373 involving property at 1609 Cockrell Street. Is there anyone here in opposition to case 373? Next case 2019-374 involving property at 1605 Cockrell Street. Is there anyone here in opposition to case 374? Seeing none, next case 2019-380 involving property at 559A Hamilton Avenue. Is there anyone here in opposition to case 380? Next case 2019-382 involving property at 5315 Hickory Hollow Lane. Is there anyone here in opposition to case 382? Next case 2019-383 involving property at 2541 Murfreesboro Pike. Is there anyone here in opposition to case 383? Case 2019-387 involving property at 3811 Hillsborough Pike. Is there anyone here in opposition? I did not. 387 involving property at 3811 Hillsborough Pike. Is there anyone here in opposition to case 387? And finally, case 2019-390 involving property at 780 Old Hickory Boulevard. Is there anyone here in opposition to case 390? Seeing none, to review, Mr. Chairman, the cases on the consent agenda are case 2019-349, 353, 366, 371, 373, 374, 380, 382, 383, 387, and 390.
All right, we have a motion for the consent agenda. Is there a second? Motion and a second. Any discussion? All in favor say aye. Any opposed? Consent agenda passes.
Members of the public, if your case was just approved on the consent agenda, you're welcome to stay, but you are free to go. Please give our staff until Monday to process all the documentation associated with your appeal, at which point you can come in and pursue the permits for which you've applied. I don't see any council members here today. So that being the case, absent any other announcements, Mr. Chairman, we're ready to proceed with the cases to be heard.
All right, let's go.
First case, 2019-303, involving property at 740 First Avenue North. Is the appellant here for this case? You can come up to the front desk. Mr. Chairman, this is a short-term rental case. I'll give the quick background. Our short-term rental staff will be here later in the meeting, but this one, as you all recall, was moved to the front due to a communication error at the last meeting. On this one, the permit was issued in October of 2017 to, I believe, a Tammy and Kenneth Rogers. Thereafter, in July of 2018, the property was quitclaimed to River Frontals LLC. The permit then expired in October of 2018, a year after it was initially issued. After that expiration, I believe they did not renew it. They operated, and he can speak to this, I believe there were 3 rentals after that expiration, but as soon as host compliance sent the abate notice, they stopped operating. So again, he can speak to those 3 rentals, but once he received notice that he did not have a valid permit, operation ceased. I believe they came in to obtain the permit based on that abate notice, at which point codes denied the permit due to the operation on the expired permit. So I think 2 issues here, the operating on an expired permit as well as the change in ownership.
And now the docket says applicant doesn't qualify under public chapter number 972. I haven't seen that on our.
It's a strange wording. The zoning examiner who typically takes these applications was out the date that this was filed. So that's just the generic language for short-term rental, or the generic public chapter, I believe, for the state statute for the short-term rental. And under that, as you recall, the short-term rental states that if there was a change in ownership, it kills the permit, and they have to reapply. And so they're no longer applying under the law in effect at the time the permit was issued, which was October of 2017. If the board determines they are eligible to reapply, they would apply under today's law.
Okay. And then they, okay. I think that makes sense.
If you'll have any other questions, I'm happy to help. Otherwise, you'll have 5 minutes. Is there anyone here in opposition to this case?
Yeah.
So you'll have 5 minutes to make your desired presentation.
Sir, if you'll state your name and address and tell us why you're here.
Alfonso Alexander, 806 3rd Avenue South. Here representing the owners of the property, representing the property management company, Playlist Properties.
Okay, and tell me what happened.
So the owners, nor we, understood that the permit would be invalid once a change in ownership existed, because we were not thinking that it was a change in ownership, at least at that point. Because the ownership changed from the individual owners as persons to a sole owner or sole family LLC in the name of the same 2 people. So when they quick deeded it over to the LLC, as was stated earlier in the year, we kept operating the property, owners and us both not understanding that that was a problem. And then as we were in the process of applying for the new permit in October of that same year, we continued to the process and then learned as a part of applying that we were operating in violation because of the change in ownership.
Okay.
And so I think the letter signifying that got crossed up because it was not sent to the owner or to us, listed as a contact people, but we were in the process of trying to get the permit renewed, and that's when we discovered that this was the issue.
And what was the last date that you rented the property?
The last date was in November of that same year.
And then is
Now
it the
that
same people that own the property now that owned it
Yes.
then?
Yes.
Okay, and so you haven't rented the property since last November, and it hasn't been listed, when you got the notice, I heard you say that when you got the notice you stopped, but
And started the process of trying to apply for a new permit, but then learned that because of the name change or the change in ownership,
Right.
I guess technically is what it is, then it wasn't eligible for a new permit because we'd operated under different ownership.
Okay.
And that's where neither of us knew that that was the case.
okay. Any questions?
If I could say one other thing, I'm not asking. I don't think the zoning administrator made a mistake, but we just weren't aware of this rule. And so what I'm asking really is if we could go ahead and start back applying for the grant or for the permit now versus waiting until November, since it's been nearly a year anyway, and the lack of our understanding, we admit, but would like to see if we could have leniency to move forward.
Okay, great. Is that-
If I'm understanding this, the owners that you represented transferred it to an LLC, which is a separate legal entity, and that's kind of where you are right now. You've got the LLC, which owns it, which is primarily for whatever purpose, it's
But-
liability, whatever.
Yes, and they didn't think that that was an issue because the LLC is single member or family member LLC, which are the same two people that own the property. They were just operating on advice from their accountant, quite frankly, which we're seeing that happen quite often, where people are changing the ownership from their names to an LLC or some other entity. And what I've learned through this process is as soon as that happens, then the permit is nullified. What I don't understand, though, is how it can be prevented, because if the day the deed is changed, then that permit no longer is valid, and it takes normally 2 weeks or so to get a new permit when you look at the process you have to go through with notifying neighbors, getting the fire marshal inspection and all of those things done. I can't see how it could be prevented. So despite that, we know we've waited a significant amount of time and are just trying to see if we can go ahead and reapply now.
Any other questions? Anything else to add?
Not at this point.
All right, we will close the public hearing and discuss. This was on the top of the docket because it was it was listed on our docket incorrectly, and it had to be noticed properly a month ago, which in essence has added another month to the time here. Since the last known rental was in last November, typically these aren't 10-month offenses. I think he's probably, in my mind, has served his time in terms of behavior, unless somebody feels otherwise. Trent?
You know me, I've been sort of the curmudgeon lately here on these. The law is pretty clear, isn't it? I mean,
Well, the law is very clear.
and they transfer the ownership, which they receive the benefit for tax purposes. It's
Well, I can't argue someone's financial best interest or legal best interest. You probably, to start an LLC, I think you would have legal protections, but financially it is a lot more expensive in terms of franchise excise tax and LLC and the annual fee filing and paying for an accountant to do your K-1s and all that kind of stuff. I mean, I think it's probably more expensive financially. I can't speak to why anybody would choose that or the other. But the clarity, my only comment on the clarity of the law is very clear for us that we can give 0 to 12 months. That's what we're looking at, and there may be some of us that think everybody should have 12, and that's fine. I mean, there are certainly some council members that think that too, and they've told us that. And I don't have an issue with people feeling one way or the other. In the past, this is a type of offense that I think has warranted less of a 1-year punishment. But like I said, I'm only one vote, so maybe it depends on how everybody else agrees. But that I just can't speak to why someone would choose to. I know why legally they might want to change the ownership, but
they probably still had to go at least get a lawyer unless the accountant is now practicing law as well as accountancy. I'm just having a difficult time getting around it, but that's just me.
well, I guess maybe
I'm more black and white, I guess.
I guess the question is, if you owned a car and then you decided to put it in your business's name, would you be expected to call your insurance, check with the state to make sure your license is still valid, or you just say, the business owns the cars now, I'm still driving the same car? I mean, to me, I don't have a if they'd sold it to another LLC and they'd been operating and didn't get a permit, then that may be a different story. That it was different members, but it sounds like it was an accounting change. But again, fair enough to look at it differently. Why there's 7 of us instead of 1?
Exactly.
Any other comments or thoughts?
I'll just say we've seen several of these cases. It's been several months
Can you
since we.
speak up in there?
Oh, I thought it was.
Yeah, we're not mic'd. We're,
Oh, this isn't.
this is recording us for everybody else out there, but not for this crowd.
Okay, I'll try to be louder. We've seen several of these cases at the end of last year. I don't know if some of y'all remember, and it seems that it's not unusual that this has happened, and people have been confused about the law and how it affects them when they change to an LLC. So this is not an unusual case. I don't recall the outcomes of the other cases, but
Any other comments or thoughts?
No, I think the law in effect at the time they got their permit did not talk about the change in ownership, and for that reason it makes sense to me that it's not an egregious violation. I'm comfortable with what you said earlier.
Okay, well, I'll move that the zoning administrator did not err and that the applicant is eligible to apply for a permit on Monday.
a second.
I have a motion, I have a second. Any other comments or thoughts? All in favor, say aye. Raise your hand.
Aye.
Any opposed? And it passes 4-5-1. Next case. Good luck.
Next is case 2019-317. If I could just briefly ask the board members to speak up. We're having a hard time hearing y'all back here, so I assume they are as well. So in y'all's deliberations, if you could speak up more than you usually do, since these microphones aren't amplifying the sound around the room. So this is case 2019-317 involving property at 6211 Laramie Avenue. Is the applicant here for this case? Yes. This is a request for variances from setback and sidewalk requirements in order to construct 2 single-family homes without building sidewalks or paying into the sidewalk fund. Before you is the zoning map showing you the zoning of the property is R8. Aerial photography showing you this parcel and the surrounding area. 2 optional site plans for submitted by the applicant. I'll let him weigh in on those, and y'all can ask questions as you need to. And then finally, current conditions of the property as evidenced by photographs recently taken at a site visit. Is there anyone here in opposition to case 317? Seeing none, the appellant will have 5 minutes to make your presentation. Please be sure to identify yourself by name and address.
My name is Paul Davidson. She said earlier this is 6211 Laramie Avenue. Essentially, prior to closing on the property, we were advised to do a few things. This is our first development, so we were advised to speak with a code examiner or zoning examiner. We were also advised to get a survey, so we did that. We got a survey. We spoke with a zoning examiner, Clint Harper, and we were told prior to closing that our setback on the Laramie Street side was 10 feet from the road. Clint stated that the HPR is what allowed for both dwellings to have Reese as the front setback side, which would remain at the proposed setbacks, and it would treat Laramie as the side of one of the units. The property was closed in May. We continue to move forward with commissioning an architect. You saw the current state of the property. Our plan was to build something with integrity that would only improve upon the neighborhood. So we moved forward with commissioning Michael Gorvich. He's an award-winning architect here in Nashville. He has done exceptional work throughout the city, and he's also spoken to some of what the new to us 40-foot setback from Laramie's side would do to the development.
Have you started building yet? Have not.
We have not started building. Yeah, we started our due diligence in January. We closed in May. We tried to be as thorough as we could, and we're told we rely on this information from the zoning examiner, and so we move forward thusly.
How did you find out the 10-foot setback was no longer allowed?
Yeah, so as we move forward with Michael, he's a smart guy. He came out for a site visit. He said, something seems a little, counter to my intuition. Go double check what you've been told as far as setbacks go. We met with Lisa Butler then at that point, another zoning examiner, and within moments, she pulled up the recorded plat. She said, okay, I see here in my notes, 40 feet on this side, 40 feet on that side. At which point my heart sunk. And so she said, clearly, Clint's a nice guy, but he didn't do his job right here, which was difficult to hear. So then at that point, I was advised that I had the opportunity to potentially appeal this, and here we are. I could speak to what Michael said about the development, if that's okay.
Yeah, I'd like to ask our codes folks,
Yeah.
how if he's saying that it ultimately is 40 on the side and 40 on the front, how does a corner lot determine the setbacks? Because it seems like one of those would be considered a side. And do you have any thoughts on kind of why we're here and what? It sounds like the address is Laramie, so it may be that Rees would be considered the side, but
So
he's wanting to
typically-
orient his homes toward Rees, and so can he not do that and have Laramie as the side?
So
And if it-
typically, the longer frontage is considered the front, or the shorter is considered the front. And so you've got the front setback that's required, and you've got the side street setback. So you've got the shorter one for the front, and then this on a corner lot, the side street setback.
And that's what Clint said, too, when I met with him. Exactly that.
So on this one, Laramie would be considered the side?
If it's the longer of the two, it looks like it's longer. It's hard to tell without measuring it.
Oh, because you have that driveway that may throw it off. But if Laramie is the side, would it be a 40-foot side setback in that?
While she's looking that up, are you orienting both front doors to Reese?
Reese side.
You are.
Yeah. To be honest, we didn't necessarily have a specific preference. It was just based on what he told us.
So, Mr. Davidson, while we're waiting, what is your hardship here?
Yeah, so I think some of Michael's comments, the architect, would speak to that. One, the 30 feet that's
Did
in
you put
difference.
something in the record?
Sure.
Did
What's
he
that?
put something in did you put a statement in?
I did. I submitted a letter. I don't know
Okay.
if that was.
I see your letter.
Yeah.
Did you submit one from him?
I don't. I
Okay.
have.
So you're talking about his comments that are in your letter that you
Correct.
submitted? Okay, I'm sorry, go ahead.
And he also just added in an email. I could present that to you if you'd like.
You can just tell me, that's fine.
Sure. So he said 30 feet in difference would enable the proposed development to be more in scale with the existing houses around it, not being disproportionately tall and narrow, which there are approximately, I would say, 15 new construction homes that a lot of people refer to as tall skinnies. And so we're trying to avoid that and maintain something consistent with the neighborhood.
I'm not sure I understand that. Are you saying there are other homes that also are within the setback, or that what you're proposing to construct is consistent with what's being constructed in the neighborhood? Is that?
It's consistent with the scale of what's existing in the neighborhood. So it wouldn't be as narrow and tall. Whereas if we were pushed into that back corner, it would have to be very tall and narrow for it to work. Because you're effectively taking 15 feet away from each building.
Okay, I understand that, yeah.
So it was that coupled with, we're not proposing to change anything with the front setbacks, anything, outside of what we were told. This was just what Clint told us the side setback was. Another big impact architecturally is the topography of the existing site is such that without the increased buildable area, any new development will end up further down slope than desired in terms of drainage and stormwater runoff, which will impact the site and the neighboring sites below ours. With the 30 feet, you can better capture and control runoff before it before it exits the site at the bottom of the slope.
But you're requesting a 10-foot side setback on Laramie?
Correct.
Okay. And that's the only request is the side setback on Laramie?
Correct.
I think is there a sidewalk?
The sidewalk.
Yeah.
Excuse me. Sorry.
And
But I
on
mean,
this-
the only variance request, I mean, with the sidewalk, yeah.
Yeah.
I don't see a recommendation from,
and-
oh, there it is right there. Okay.
And so you're not okay with Metro Planning Commission's recommendation on the sidewall?
It's not that we're not okay with it. Frankly, we'd be willing to move forward with that recommendation.
Okay, so you would be okay with Metro Planning's recommendation on the sidewalk, which is to contribute in lieu of construction for Reese Avenue property frontage, and then to dedicate the right-of-way along Reese Avenue. You're okay with that?
It wouldn't be preferable,
But you can live with it?
but, if that's what we had to do. Yeah, I mean, as far as the sidewalks went, the other thing I think I stated in my letter, there's roughly 10 feet of unbuildable right-of-way currently, in addition to the 10-foot requested. And so, effectively, we're set back 20 visual feet before any building structure. The proposed sidewalks would interfere with that pre-existing drainage and culverts on the parcel. So therefore, the sidewalks would need to be pushed even further onto our building envelope, and that would just unfairly infringe upon living space. There also aren't currently any existing sidewalks on either Reese or Laramie. The approximately 20 homes that have been built within the last 5 years or so, they were built prior to the sidewalk fund going into existence, so there was no contribution or build.
Do we have any information
So
for
for
us?
the side street setback, according to 1712-030, it depends on if 030A, it's a table in the zoning code. It depends on whether the street is a minor local or a local street or a major, all other streets. And that's designated in the major and collector street plan, which I don't have before me today. The zoning examiner who took this application presumably would have looked at the street and made that determination. So based on the application that was filed, it appears that the zoning examiner looked at the major and collector street plan, determined that it was not a minor local or a local street, and therefore the side street setback is 40 feet.
And the first examiner might have thought it might not, that might have been what the first examiner missed. If it were a local street, would it be a 10-foot setback?
If it were a local street, it would be a 20-foot setback.
20 foot, okay. So we're not sure why the 10 ever was told, but that's, I mean, the people who you testified about are here to know that.
We still got to deal with the sidewalks at some point too. How much impervious?
Well, the sidewalk, he's agreed to the recommendations on the
I
sidewalk.
didn't hear that. I heard he didn't really want to, but he might.
Well,
I
I
don't
mean-
think he was listening to
Yeah.
the comments of my esteemed colleague down at the end of it. But
Well, let's tackle the variance, and or we can tackle the sidewalk first if you want to tackle the sidewalk.
it make me feel a little better.
Okay, then I'll move that we approve the variance for the sidewalk as long as the conditions that the planning department has recommended are met, which are that he pays the in lieu fee on Reese Avenue and dedicates the right-of-way along Reese Avenue. Those are the sidewalk recommendations.
I'll second that.
We have a motion, have a second. Any discussion? All in favor, say aye. Aye. Sidewalk variance passes based on the planning recommendations. And now for the variance, did you have anything else that you wanted to say? I didn't officially close the public hearing, but
Yeah, I mean, I would just say, you know, we're trying to build a product with integrity. You know, we don't want to build something that's cookie cutter. We wouldn't have hired Michael Gorbich. You know, it's not that we want to spend 5 times the amount of money just for the sake of it. It's not reckless. He's going to add an additional level of profession and design care throughout the entire project because of that.
the only question I have, the remaining question I have is, I know you're asking for a 10-foot variance, and
30 feet.
No,
I mean, a 30-foot, but you were asking for a 10-foot setback, a 30-foot variance.
Right.
You know, is 20-foot, a 20-foot variance, is that something that you can, would that cause any kind of concern or undue burden? I know you want 10, but it sounds to me like this isn't an unusual case. We've had corner lots like this before, where you have to determine the side setback, and we've had streets that were technically in the planning as a major street, but doesn't really behave that way. And I don't know that this one does or not. That's up for everybody to decide. But how would a 20-foot setback affect you instead of the 10?
It's better than 40.
All right. There you go. That's what I wanted to know. All right. Any other questions or comments? All right, we will close the public hearing and have a discussion. We've had cases like this before where you have a corner, and to me, there could be a case for hardship if it's believed that defining it as a major street, requiring a deeper setback, isn't really applicable to the way the street behaves. And we've had that many times on 10th Avenue South, 12th South. We've had some cases where we said, the lots become unbuildable. I don't think this is an unbuildable lot. It may be closer to that for 2 homes than with 1. But I think because of the corner lot, I would be willing to at least think about a 20-foot setback.
25 or 25. You're cramming everything in there so tight at some point in time.
Well, the point, to me, the main point, to me, the main point is, if you're on a corner lot, one side should be legitimately considered as a side setback.
Right.
And what is the reasonable side setback? And it's not, and if it were a major street, it's 40, and just a residential street, a side setback is 20. And to me, that the combination of getting 2 different answers from codes folks, and yet having a legitimate side setback. I mean, we're basically saying this street may behave as a regular street, not a major street, and so he's got a 20-foot side setback.
I agree, and I also think because he's got the 10 feet of non-buildable area, it does bother me that we have what looks like a neighborhood of single-family homes, and they're all set back all along Laramie further. At the same time, that is a larger lot, and I think it on the overhead, it looks like there is sufficient room for 2 houses. And so it doesn't seem equitable that there would be 40-foot setback on both Reese and Laramie to me. So to me, I have some room to move on that side setback, what we're calling the side.
Are there photos taken of the existing home from Laramie?
You gotta talk louder, they know you can hear.
Emily knows. Okay.
She's got small child, so topography and ditches.
That's what I was looking for. The next one? The next one. Yeah, it slopes a bit.
The bottom one is existing, is that what that is? Is that what that
Yeah.
is? Yeah.
So, Chairman, so that I understand, because I didn't see any hardship when he spoke, and I appreciate that you're trying to build something that's very nice. You're saying there's a hardship because Laramie requires a 40-foot setback because it's considered a major
I think
major
well, and
street.
we don't have. That was the assumption that Emily said. She said she doesn't have access to the actual, but that would be why it would be considered 40. Is if it were a residential street, it would be 20. If it was considered a major street, but then I'm just saying in the past we've had streets that people came and argued, hey, this is a major collector street, but it's really not behaving that way.
So what you're saying is the hardship would be to this applicant is that Laramie, even though it's classified as a major street, is not really a major street or may not really be a
I would
major
say that
street.
it's behaving as if it was a street worthy of a 20-foot setback, and that there's an additional factor in that there was confusion with the examiners at codes, and you had 2 different answers. So even you may have had one that pre-sale thought of it in one way, and then when they went back to double check,
Well, I
they
think
got a
he was-
different answer.
They were originally told by codes, I think according to the letter, that the setback was 10 feet. Is that right?
Right.
So that wouldn't correspond with them mixing up 20 feet or 40 feet.
No,
And I hear what you're saying. I guess where I'm struggling with is that there hadn't been any evidence presented that Laramie is not a major street. I mean, it could be. It might not be, but I hear that the codes department has made a determination that it is, and that therefore there's a 40-foot setback, and I hear that it may not be, but I don't hear. There's been no proof of that. That is just a possibility. So, and I'm willing. I mean, I'm open to hearing that proof. If maybe a deferral so we can hear more about that would be appropriate. I think what you're saying is it makes sense to me, but I think I'm also being asked to just assume that may be the case, and therefore let's find a hardship. So
is it and that's a good point.
I'm sort of in the same boat, by the way, as Russ is on this one. I mean,
Well,
I'm not finding that hardship. It's sort of been created by the owner. And it very well could be, but Laramie is can we go back to the street, not necessarily the picture, bingo. Laramie, it's a dead end right there, so it may not be. And I think, whereas Reese isn't, you've got a dead end there, so it probably isn't being classified correctly, but are we supposed to assume that?
Well, I think that given the concerns that have been raised, that it may, are there those concerns shared by everybody else?
I think it's
Uncomfortable
valid.
based on what I've seen.
I think it's valid for the applicant to come back to us with
Okay.
more.
good, 'cause I can't hear.
Well, yeah, sorry.
Deferring it.
Yeah, I just basically just wanted to see if there were 3 of us that wanted
Sure.
to hear it, to stretch it, and I think there are. And so I think it does make sense, because if there are 3 of us that would like to hear more, you're not going to get 4 votes today. So that we defer this one meeting. And I think during that 2 weeks, it would be worth talking with the codes folks again about, really what is the right orientation, And, if they're oriented to Laramie, is Reese have is that side setback different? And then also help us understand, and maybe through talking with codes too, how this street may behave differently in a way to lower that setback for you. I think you may hear at least a desire to explore that option for you.
And I think what would be influential is if codes were to give us information that they did not consider it to be a major street.
Or that the setback wouldn't wouldn't impact the nature of the street. Is that?
Well, I suppose that might help. I think that they obviously have standards by which they determine whether it's a major street or not. And if it's classified as a major street, but it's really not meeting those standards, I'd like to know why and know more about it.
Okay. All right. Well, you've heard the comments, and I will move to defer this 2 weeks to the next meeting to gather additional information.
Second.
A motion and a second. Any other discussion? All in favor, say aye.
Aye.
Any opposed? Great. Thank you. We'll see you in 2 weeks.
Thank you.
Before we move on to our next case, I have another announcement for a deferral. Case 2019-381 involving property at 265 Old Hickory Boulevard East. The applicant has requested a deferral in order to continue work with planning on the sidewalk issue. This is a sidewalk variance request.
Perfect. We don't need to make a motion. Okay.
381.
Next case, 2019-332, involving property at 0 Herman Street and 1501 Herman Street, requesting a special exception from the setback and step back requirements in order to construct a mixed-use development, mixed-use building. Applicant is here. Is there anyone here in opposition to case 332? So before you now is the zoning, showing the zoning of this property is MULA. Aerial photography showing you this parcel as well as the surrounding area. Site plan submitted by the applicant. And finally, the photograph showing you the current conditions of the property. So, Mr. Piercy, you'll have 5 minutes to make your presentation. Please be sure to state your name and address.
Thank you. My name is Philip Piercy. I'm with Callis Design Group, 5016 Centennial Boulevard, Suite 200, Nashville, 37209. This project, as she mentions, is located on Herman Street. It runs all the way through from 14th to 16th, so it has a lot of street frontage. It, based on the street frontage on Herman, the Codes Department has said that the rear setback would be the south boundary that backs up to the railroad. It's a 40-foot spur railroad that goes up a couple of industries just inside the interstate loop. That setback on the MULA zoning would be a 20-foot deep setback. If we didn't have frontage on Herman and only had frontage on either 14th or 16th or both, it would be a side setback, which would be 0. And so we're asking if y'all would consider reducing that rear setback from a 20-foot wide width to a 5-foot width. In addition, the MUL zoning requires a step back on the 4th floor from the face of the 3rd floor. So you can come up with the 3rd floor up straight at the property line or within 15 feet of the property line. And then the 4th floor must step back 15 feet. And we're asking to be allowed to bring that 4th floor out to the face of the 3rd floor. It loses a lot of inefficiencies in there trying to line up stair towers and everything else, chases and all kinds of stuff with that, with the development, try to step that back. And with the amount of frontage that the site has with 3 frontages and a very long frontage on Herman Street, it highly impacts this site, maybe more than some others. With the development, with y'all's consideration and approval of that, the developer would be willing to put in additional affordable units. They're going to pursue the provisions in the ordinance that allows the residential portion of the building not to be counted against the FAR if you include a percentage of affordable housing, and so they're going to do that and provide affordable housing to meet that requirement. But if this was granted and allowed them to gain more efficiency in the building, they would provide 10 additional units above what's required by the percentage. We had a neighborhood meeting last night, had one neighbor attend, and he was in support of the project. Councilmember O'Connell also came by the meeting, and all indications that we had from him was that he was in support of it. I don't know if he's responded to the staff, but planning also submitted an email to me today saying they were in support of the approval. Be glad to answer any questions you may have regarding the project, but would appreciate your consideration.
Any questions right now?
In the application, it states that there's 60 foot is the maximum height allowed, and is that right?
I think so on the fourth floor.
And we have a drawing with building sections.
Mm-hmm.
Can you address those? There's a number 1 building section. It says with step back plane, and it looks like 5 stories are shown.
And that first one, they had looked at, and the architect's here, but so tell me if I speak the wrong. On the first version on the left is kind of what could be built under the ordinance with the step back. What's the 5th floor was a mezzanine level, which was, my understanding was wouldn't count against the floor. It was just a high ceiling in the upper floor, and so that would still meet that. But if we could shift it out, they would be interested in building what's on the right-hand side, which would just be the 4 floors. And our point was it's the massing of the building is no more obtrusive or greater under the 4th floor condition that we're asking for than it is with what we could build.
So it looks like what I'm zooming in and seeing is it's proposed to be 45 feet tall with a little parapet.
Yeah.
Is that correct? Okay, so much less than the 60 feet.
Correct.
The one on the left would be
So that was on
a
either
taller
floor, right?
and different looking building than one.
Yeah, I think what they're
This is
what,
either, but this is what they want to do.
right.
Could
This is
do-
what they could
could
do.
be more.
That's
Right.
the left would be what's allowed.
Right.
And then can you go back again to the 0 foot setback on neighboring properties? Is that what
So if the Herman Street frontage is what sets the railroad on the south is our rear setback. Under the MUL A,
So the top is
Yeah.
the north side of the plan is Herman, and the south side of the plan
is the railroad.
Okay.
And so if we didn't have the frontage, if we just had a through lot that went all the way through from 14th to 16th and didn't have frontage on Herman, we would have 2 fronts and 2 sides, no rear. And that side setback would be 0. We'd be able to build right up to the right-of-way of the railroad. And our point is, we'll give 5 feet. There you have a 40-foot wide railroad right-of-way, and so nothing else can be built up close to us anyway. It's a spur line that has limited traffic on it. That
I
goes
see.
up
So
just a
if the
couple
railroad
businesses.
was an actual road, you would be allowed a 0 foot.
If it was an actual road, it would apply to the 0 to 15 foot as well. So we could have a 0 if the railroad was a
0 lot
road.
line.
How many affordable units are required by the code?
25%.
25% of the total units minus 10. So it's around, depending on how many you can get, it's around 70 total affordable. If we got both variances approved, we believe that we could potentially get around 20 additional units, which instead of the 25%, we would add 50% affordable. We would add, of the 20 added, we would add 10. So we would, essentially.
So you're going to say you're adding 10 more?
Correct.
I thought I'd heard
Yeah.
5.
10.
5
So
would be
you're going to have
required.
25% of the total. So 25% of the total units will be affordable housing, not the minus 10.
Yes,
Basically.
yes. Well, it's
If that were conditioned, you're agreeable to that?
So the code states for the FAR bonus, it's 25% affordable times the total units minus 10. And we're saying that if, let's say we have 290 units, if we got the variance approved, we could add 20 more units. Of the additional 20, we would give an additional 10.
Right.
So instead of 5 additional, which is what the code would require, we would give another 5 essentially as goodwill. So add another 5 affordable
And I'll go, I just want to jump in real quickly. I don't think this person stated his
Can you
name and
speak up,
address.
sir?
I don't think he stated his name and address, but then the second thing,
Yes.
so although that is a part of the code, the affordable housing, there was state legislation, Title 17, or Title 7, Chapter 13, that prohibits a municipality from enforcing any code, regulation, or law that conditions a variance, a land use restriction, or any other change for zoning on the condition that they sell or rent below market housing. And so, although this applicant has voluntarily subjected themselves to that, in considering the variance today, the board can in no way condition its approval on their agreement or promise to provide below market rate rent or houses for sale.
But that's the condition that, but that's how, I appreciate, but the planning department's recommendation was based on that voluntary approval. It specifically says that. It says if they weren't going to voluntarily do this, we wouldn't recommend approval.
Well,
And that's fine,
so-
but I don't think it changes the legality.
So I guess, so
basically, and again, Mr. Poole can correct me if I'm wrong or feel free to step in, but planning has made that recommendation, but planning's not the one it's voting on the variance. And this board is legally prohibited by state law to grant the variance based on that condition. Now, you can grant the variance outside of planning's recommendation, or, if planning had recommended, for example, disapproval, the board still has the authority to grant the variance. So the fact that planning conditioned their recommendation of approval on that affordable housing, that can't be the condition. That can't be the reason that you grant the variance per state law. Again, they can still voluntarily provide the affordable housing. Everybody's all for affordable housing. That's great, but that can't be the condition or reason that y'all grant the variance.
And all that's great, like I said, but it wasn't even on our radar screen until it became part of the recommendation from planning that gives us recommendations on special exceptions. And so that's, I think, the only reason it was even something I would even think about is because it was very specific. So I'm glad to have the clarity and I understand where it is, but I'm not sure how it got clouded by that, but it did. So.
I just noticed that it's listed as a special exception, not a variance.
That's because it's
and-
within the UZO.
Right.
So there's a specific provision in the code that says properties within the UZO for setbacks are considered a special exception, and planning does weigh in on special exceptions. So it's the functional equivalent, but in terms of the fact that you're deviating from the code, but it is a special exception.
And as opposed to a hardship, or as opposed to a variance in which they would need a hardship. They don't need a hardship in this instance.
I believe the code section, it cites the conditions that you have to meet for this, and I can tell you what that is. It's not a
Pedestrian
hardship.
friendliness
You're
and
right, it's not a hardship.
not
The code
impairing
points you
light
to-
and air, things like that.
I'm sorry, I can't hear you.
Not impairing on the neighboring properties and their right to have light and air, something to that extent. Do you all know?
I believe
Well,
it's
I mean,
17,
the building's 45 feet and the right-of-ways are all more than 50, so I don't see that being an issue. And I'm certainly, neither one of us are attorneys, I don't think. I'm not. But our presentation is that we would provide the affordable housing and provide the additional 10 units.
And I'm Alex Tempolsky, by the way. I'm the owner of the property with Alpha Capital, and we're in 380 Bridgeville, or 44 Abilene Road, Bridgeville, PA, 15017. And to address the affordability, or in the zoning code, the FAR calls for a 1.0 on the property, and so you can take a voluntary bonus in FAR floor height under the height restriction if you include 25% affordable units. So we're looking at as essentially, we can either build it at a 1.00 FAR, or we can have an unlimited FAR for residential up to that height. So, and that's in something that we would consider not mandatory, but something that's voluntary for the height.
But you would be required, in order to get that floor area ratio, you would be required to have the housing, and so that would be the check on
Yes.
Correct.
Correct.
Since it's not, since we're not allowed to add that as a condition, you are imposing it on yourself by choosing a different floor area ratio, is what you're saying?
Because we're essentially
Okay.
volunteering it.
That's really, that's.
I just want to clarify that.
Thank you. Any other questions or comments?
So, can you clarify again the standard that applies for a special exception for us? And I'm looking right now at,
So a special exception is different from a variance in that they don't have to prove a hardship. They have to
Correct.
prove that they meet certain conditions in the code. And that's something that code staff cannot administratively determine. Even if we think they meet the conditions, we don't have the authority to say you meet these conditions. Those conditions have to be, the board is vested with the authority to determine that they meet these conditions. So,
and so the conditions here are 1712.020D, correct?
the conditions here are under 1712.035D. It talks about
035D.
setback regulations within the UZO, urban zoning overlay, which this is. And it says, the applicant shall provide evidence to the board that the proposed building setback shall not create an adverse impact on adjacent properties, nor detract from a strong pedestrian-friendly environment. And then it also references 1712.060F3. And that talks about that the proposed building height will not create an adverse impact on air, light, shadow, or wind velocity patterns due to the configuration of the building relative to the maximum permitted height standards. So it's all about height and this additional height within this build-to zone would not have an adverse impact on the neighboring properties.
So that's really the standard, isn't it?
That's right, for
Okay,
this particular
so
special
no adverse
exception.
impact on neighboring properties is what we're.
For this particular
Okay,
request,
so
yes.
even if they don't meet the special exception requirements, if there's no adverse impact, we can essentially approve it.
Well, that's the requirement, is that there's no adverse impact.
Correct.
Right.
Any other questions? Do y'all have anything else to add?
Yeah.
You have a question? All right.
If we grant it, I just want it on the record, there's no consideration of the affordable units or any of those
Right.
items that are.
Okay, well, we'll close the public hearing, and then you can make your,
Yeah, I had to just figure out how to word that one, but
Well,
we
it-
have to be within the state statute and then go forward.
yeah, I mean, and maybe I read the planning department's recommendation one way, and as the applicant explained, as it relates to floor area ratio, I think that's, if they want to have a denser property, they're required, they can do that if they have affordable housing, so that's their choice. And to me, I guess that's I'll reinterpret.
It's the free
I'll
use of their
reinterpret
own
the planning
property.
department's recommendation to say that they're approving it on the assumption that as they build as presented, which has a denser floor area ratio, that they have to have the affordable housing piece, which they've. I
It's a
think
good
those.
aspiration. I
I
just
think
don't
those go hand in hand, at least as testified by the applicant. If you're building as they have provided it, it will have to have the affordable housing, or it won't meet the floor area requirements. Is that how you all understood that? So
what I understand.
so in other
is-
words, we can approve it with reasonable confidence that the affordable housing will happen because it's tied to the floor area ratio, not any requirement which we're not allowed to make by Tennessee state law.
That was such a good legal statement. I like that.
For the non-lawyer on the board.
So what I'm understanding is that even though they don't meet the setback and step back requirements under the MULA district requirements, that if there's no adverse impact on surrounding properties, it's like a variance, except there's just one key here, which is there's no adverse impact, and I don't.
And there's no
I don't
hardship.
see any. I don't. Also, I think the railroad, the 40-foot easement with the railroad behind them, to me is.
Okay.
Yeah.
I mean, how are they going to create an adverse impact on the railroad? So,
Are you okay with the variance? You want to make a motion?
is it a it's not really a
No,
variance.
the special exception, sorry, the case.
Well, that's what looking at the application. It does say that it's a variance request. So I wanted to see if we could get that clarified.
This was filed as a variance application. It was originally scheduled to be on the last docket. In preparation for that docket, I realized it was within the UZO and therefore improperly applied and noticed as a variance request. So we advised that they also had not done the neighborhood meeting as required. So we advised them that it should have been a special exception and deferred it so that they could do the neighborhood meeting and we could proceed with the special exception.
And they testified earlier that they did have the neighborhood meeting.
That's right.
So I would move then that we approve the special exception with the conditions placed on it that have been agreed to essentially with Metro Planning.
I think it's my understanding, let me just make sure I understand, that if we find that the standard for a special exception is met, we don't really have any discretion but to grant it. And I think that's all we have to do here is move to grant the special exception. Is that
That's generally true, yes.
accurate? Okay.
And
Okay, so let me amend it then to
I
say
think-
that
Just general approval.
I move that we approve the special exception.
Have a motion?
I'll second.
Have a second? Any other discussion?
I think there's some discussion down there.
Can I just make one request that you reopen the public hearing for the applicant to change from variance, which is what it says, to special
No,
exception?
I think that what Emily had said was that was done. That was,
So we are there, and they
That's right.
understand that's what we're here for.
That's right. That change, I'm sorry, apparently was not reflected on the docket, but it,
Okay.
yeah, it's on the docket, but it's not on, I think it was on the application, the written
Okay, I'm looking-
application.
There's not an amended
right.
application.
The
We're
docket
just-
was, right.
We're,
So,
Got it.
the evidence, the application is conforming to the evidence presented.
Correct.
yeah, properly noticed and the meeting held. Any other discussion? No. All right, all in favor, say aye.
Aye.
Any opposed? That passes. Good luck.
Mr. Chairman, if we could take a brief break, I think we might need to rearrange the configuration so everybody can hear a little better. So if we could
Okay.
take a break to do that.
All right, we're going to reorganize so everybody can hear.
Move some tables.
Has recommended, has to have the right to contribute to the in lieu fine.
Second.
I have a motion, I have a second. Any discussion? All in favor, say aye. Aye. That passes. Next case.
Next case, 2019-345, involving property at 705 28th Avenue North. This is a request for a special exception to use a single-family home for a home daycare. Before you is a zoning map showing the zoning of the property as RS5. Aerial photography showing you the property and the surrounding area. Site plan overview of the house submitted by the applicant, and finally the photograph showing you the current conditions of the property. Is there anyone here in opposition to case 345? Seeing none, the applicant will have 5 minutes to make your presentation to the board. Please be sure to identify yourself by name and address. Before we get started, bring this to your attention again. This is a special exception. There's no hardship required here. It's just the conditions that have to be met.
Right. Yeah, if you could state your name and address, and then name and address first, then I have a question.
Jackson, address 705 28th Avenue North. Valerie Patton, address 705 28th.
Okay, and this is a special exception, so I wanted to make sure you did have your neighborhood meeting?
We did.
Okay. That's if you didn't, we got to stop. So now that you said you had it, tell us what you're trying to do, and tell us about your neighborhood meeting.
We have an in-home daycare. We've been having it for a while, and we can only have up to 4 kids, and we would like to be certified to have up to 12.
So you currently have a daycare in the home?
Yes.
Okay.
And tell us about your neighborhood meeting.
No one came.
Right.
It was perfect.
Well, but because the people, I guess, do your neighbors know it's a daycare now that you have 4 kids?
Yeah, we've been there for a while, so they know. We did get one. We sent out letters, and we did get one letter that said support, and I believe it was from like the Chinese food restaurant up the street.
Okay. Okay. Any other questions? And the planning department has recommended approval of this special exception, and I know that some folks have asked in the past, about safety concerns and those other issues that, and it's been pointed out that the state regulates those pretty strongly, and that by us approving your special exception, you still have to go through the process to
We understand.
convince the state and regulatory agencies that you have met all the requirements and are set to handle the 12 kids. So, did you have anything else to add to us?
No, sir. No.
Any other comments? We'll close the public hearing. Thoughts?
I take it that with nobody at the neighborhood meeting, I'm going to take that as approval, which I think people watching should understand. If you don't voice opposition, we think that people are in agreement, or I do. I believe they have shown that they meet the requirements for a special exception. Planning has recommended it. My thought is it's appropriate.
Is that a motion?
And I'll make that a motion.
Have a motion, have a second. Any other discussion? Okay, all in favor, say aye.
Aye.
Any opposed? That passes. Good luck.
Thank you.
Next case. Page 6.
I missed the consent agenda.
Next case, 2019-354, involving property at 2400 Nolensville Pike. This is a request from a variance from maximum fence height requirements. Is there anyone here in opposition to case? Yes, there is. So we do have opposition to this. Before you is the zoning map showing the zoning of the property as CS. Area photography showing you the property and the surrounding area. Site plan submitted by the applicant shows you the property, I believe where their fence is. And finally, photographs showing you the current conditions of the property as well as up and down the street. That's the existing fence that's at issue today. With opposition here, each side will have 10 minutes, so please be sure to identify yourself by name and address. And of course, if you want to have a period of rebuttal, make sure you reserve some of that 10 minutes.
All right, if you can tell us your name and address and while we're here.
My name is Hamid Rabi, and on 2400 Nolensville Pike, I'm an owner. And I bought this property in 2017, and I started my business there. And after like a week, they broke in at night. They stole the computer and the TV, and actually they busted the window. About 10 days or 12 days after that, again that happened. So I installed those fences, and since then I never had any problem. And that's one of the most beautiful fences in those area. Even the code department person who came and inspected, he said it's so beautiful. It's not the ugly fence.
I'm sorry, I didn't understand the last part.
I said
Codes came out.
That fence, that kind of fence, it cost me $23,000 to install it. It's a iron fence, and it's so beautiful. I mean, as far as the
And you built that
material.
fence in 2017, is that right?
February 2018, I believe. It was February or March 2018.
And how did you get notice that it was not in compliance?
About, I think, 5 or 6 months before, I received a letter from code department, and just I realized that there was some restriction and I didn't know about.
Okay.
I guess there were a couple of letters from folks, and we haven't heard from the folks that are opposed to it, but one of the concerns was that the fence impedes the view turning from Peachtree. And, I guess that you have a pretty pointed lot, it looks like, right there on Peachtree in Nolensville. And is there anything that could be done to basically maybe take out that corner to help with the view?
You mean setback or just?
Well, I mean, I think
You could set back that corner. It seemed like if you set back that corner, it would make a difference.
Yeah, I mean that if the corner were instead of coming to a point, maybe,
I know what you mean.
Either cut off.
and it may, but, and again, we haven't heard from the opposition, but from the letters that we received,
Because
one of the concerns that they had talked about was the visual safety that the fence, impedes. I mean, it causes, in their mind, a safety issue because of the inability to see when they're on that Peachtree Nolensville corner.
Well, and it's 9 feet tall, is that right? How tall is your fence?
6,
It's 6, and
Yeah.
what is the maximum height?
I believe it's 3 or 4.
Okay, thank you.
And did you get a permit when you built the fence, or have a fence company build the fence? I mean,
Fence company did it, but they don't need a permit.
the
I
fence
think
company should
there's-
know the rules, shouldn't they? I mean, I guess that's you would think so. I mean, I'm not telling you you
Then
shouldn't.
not really.
I'm sure that's the first thing you thought when you got the letter to come here. But
Now, what the point is that I have 2 other places in Gallatin Pike and Charlotte Pike, and before that I installed the same fences, and I mean, I did a long time ago in 2011 and 2015 or 14, and didn't have any problem with them, so I wouldn't think about it.
Right.
That I would have problem here.
Okay. Any other questions right now? Do you have anything else to add right now? You will have 9 minutes for rebuttal after we hear from the opposition. So you'll just take your seat again, and the opposition can come forward. Yeah, absolutely. Come on. You will have 10 minutes combined, so you're each are free to speak, but just know it's 10 minutes combined. So somebody goes 9 minutes, the other one has 1. Yeah, if you would state your name and address and your thoughts on this case.
My name is Barbara Clinton. I live at 313 Peachtree Street. So I'm about 6 houses away from this fence, and there are a number of problems with it for the neighborhood. One of the most serious is that traffic is now backing up in the mornings all the way down Peachtree Street to the next cross street, which is Burbank, and sometimes even beyond, because the height of the fence means that if you want to make a right turn and you look to the left to see if the traffic is coming, you can't see. So people would normally be making a right turn on red, but they can't do it safely, so they have to wait for the light to turn. So that's one of the issues. And I'll let my neighbor add to that discussion.
Van McMinn, 309 Peachtree Street. The problem is, as Barb has just said, we can't see to make a right turn onto Nolensville Road from Peachtree Street. It was already difficult before because it is, you've noted, it's a sharp angle, about a 70-degree angle where Peachtree meets Nolensville Pike. But now it's become virtually impossible to make a right turn on red there, unless you just want to take a chance. And then it's very dangerous to try to pull out there. But as Barb has also mentioned, the traffic is backed up well past our houses, and it's even difficult for us to get out of our driveways because the street is blocked by traffic trying to get off Nolensville Pike.
Is there an amount of that fence that could come out and cut the angle to where you could see?
Well,
I mean, if we were to allow the applicant to keep the fence, and I don't know I don't know, can't predict what's going to happen, but I'm just asking, is there if it came back, 15 feet each direction, and then
without being an expert on fences and vision and that kind of
Yeah.
thing, we feel in the neighborhood that code is there for a reason, to protect the safety of the people who are trying to make those turns and also pedestrians. So we don't see any reason why there would need to be an exception. There's been a used car lot there for, we think, about 30 years, maybe more. But there was never a high fence, so that it's never been a problem until the current owner put the fence up. So we don't see any reason to do that, to do what you're suggesting.
okay. Any other comments? Oh, man, okay.
I'm sorry.
No, you're fine.
So Phyllis Wilson, and I live at 101 Bacon Drive. I'm not extremely close, but I drive the Nolensville Road and Peachtree and other streets in that area quite often. my opposition, and I understand yours because I've driven that in the early morning hours, and so I agree with what they're saying, but I also have a problem with, there are codes restrictions on fences. Many of those have been brought to the attention of this board in recent months. Some are probably pending in the Nolensville Road corridor, and it's just not fair for one property owner to get an exception because he has a beautiful fence when others have complied and made their fences more within codes restrictions. And so it's not just this corner that we have, it's the entire frontage that needs to be addressed as well.
Okay. Any question?
It's the totality of the fence.
In the front. I mean, I think there's, I think the side restrictions are different on fencing, someone would have to correct me, than the front height.
Okay. And that is correct, I just don't know what it is.
I don't have the exact numbers.
Yeah. Any other questions? Is there anything else that you all would like to add?
No, as the neighborhood, we're trying very hard to keep Nolensville Road a decent place to be, and the used car owners in general have had a tendency to skirt the regulations, and so the neighbors are pretty watchful of this kind of thing.
Okay. Great, thank you. All right, we'll hear back from the applicant. And I think you have 9 minutes and a few seconds for rebuttal.
I mean, I can cut part of it, but by having this fence, we keep the thieves away from this neighborhood. We save hours of Metropolis time to come over there and write a report every day or every week. I mean, thieves get there, they cut the catalytic converters, even if the car parks outside. I know other dealers, maybe they prefer to not having the fence, but the problem is that for car dealers, they like to show their cars. So we have two choices: or deal with thieves, steal stuff, or just show our cars and sell more cars. So some of us prefer to do that. But I like to go to bed every night with peace of mind, not getting called from alarm company every night or every other week in the midnight to drive all the way there, and I see my window busted, my computer is not there. So I think for neighborhood, having the fence even is good. Because if they start coming there and steal things, next time they're going to go to their houses or to their cars. I don't know.
I think the neighbors are saying they don't really like the dealerships there.
Well, we pay too much taxes. If they look at the sales taxes that we pay, I think in Nolensville Road only, they pay millions of dollars a year just sales taxes. No other businesses in Nolensville Road pay that much sales taxes. They can look at the record. Neighbor can look at the record of them.
Do you have the ability on your property to put your inventory either on the side or in the back in an enclosed fence, or does it have to be where it is?
No, it just is almost less than half acre lot. It's very small, and part of it is an office building. So I can have like 30, 40 cars maximum there, maybe 50 max there, and there is not really enough room for cars. I mean, I can do something for the corner, I mean, if I have to.
Did you make any investigation prior to putting the fence in, what the regulations or the codes were on the height?
No, as I said, I have in Charlotte Park and Gallatin Park, and I have the same fences with same height, same material. I installed them before. I never had problem.
But you didn't check on it before you did this? So
No, I asked the company that they installed there, and I told them I want to do the same thing here, and it cost way 2-3 times more than chain link fence, but I prefer to have a nice fence instead of just one.
And there's no shortage of cases that we've heard from homeowners or business owners who call a fence company and say build a fence, and because they're not required to to get a permit for the fence, and it's the homeowner or the business person that ends up before us, not the fence company, which seems a little, you know.
I don't disagree
Yeah.
with what you're saying. I'm just.
Yeah, that's.
But yeah, but you know, you're right. I mean, it's not, and I'm not saying there shouldn't have been more, but
Yeah, I wish they
it's
had
not
a-
uncommon for us to
Yeah,
have this.
I wish they required permit at least. You know, we had to go through those, but
Right.
we didn't know, and I spent, as I said, $23,000 on those fences.
Right. Anything else that you'd
No,
like to add?
that's it. Thank
Any other questions?
Have you considered moving the fence back? I mean, I think there are regulations on how you can have a fence. Am I saying this correctly? You can have a taller fence, but it's got to be further back. Any lawyer know that?
I have no clue.
Can you hear me? I was
I
asking.
can hear you when I'm paying attention.
Hello? I was asking, I think you can have a 6-foot fence, but it's got to be further back. Is that accurate?
That's right.
Okay.
The fence cannot be greater than 36 inches, and it cannot be, trying to get the exact numbers for you.
In my mind.
Fencing or walls within 25 feet of the public right-of-way shall not be higher than 3 feet. So if you're not within 25 feet of that right-of-way, then you could presumably go up.
Okay. And that's on both those on both sides for him. Okay.
Any other questions? We will close the public hearing and discuss thoughts.
It's a safety issue. He did it. He should have checked before.
Yeah.
But it's a safety issue both ways. We've heard several of these where we've heard several auto owners come and tell us about how many police reports they filed, how many, like, we've heard this story several times, so I believe that this area is probably more prone to this type of sort of this type of crime than other areas, and so I think it's a sort of weighing both safety issues, and so I'd be more interested in crafting some sort of compromise as we've done in the past, because I understand the neighbor's perspective, but I also understand the business owner's perspective in trying to protect his inventory.
Well, and, you know, and we did, you know, I know the councilman, and I don't know if he represents this property, but we've had councilmen, members come and, you know, really not want a chain link fence. And some have been amenable to this type of fence, which is very attractive. But to me, the safety issue on that corner is paramount. I mean, I really do think that you know, if we allow the fence to stay, that corner has got to be somehow cut out in a way that creates greater visibility, or at least ample visibility for the street. I don't know that I have that expertise, but I am leaning toward being more willing to think that through before I just say no. But at the same time, I get both sides of it. It's I'm empathetic to the story that we hear over and over.
Are you saying the hardship would be the nature of the criminal activity in the area?
That, and because it's sort of, he's at this narrow, it sounds like it's on the corner and he's sort of on the narrow, but I do.
So it's the size of the property too.
Yeah, but I also, the neighbors make a compelling point about not being able to make a right turn. So I think it's an odd shape kind of lot, the way that it's sloped. And so I think that there's an argument that there's a variance, but I don't know necessarily. And it's not, you know what, it's not really my job to craft the solution. Maybe we defer this and let the applicant come back and sort of see if he can work with the neighbors on sort of improving the visibility, but also maybe maintaining his fence. So that's my suggestion. I'm done talking.
No, I think I would want to know more about, nobody's been able to say that they, with any certainty, how far back you bring the fence before the safety issue is eliminated. I don't know that they need to go as far as having a traffic engineer. Maybe they do. I don't know. But I'm with you. I don't feel like I have the ability today to, if we wanted to craft a variance, I don't feel like I've got the information I need to do that.
Whether it's meeting with,
I agree.
yeah, either meeting with Public Works, meeting with the neighbors to mark it off and have a better sense, or the traffic engineer, as you said, but, and that may all be viewed as more costly and time-consuming than complying with codes, but that would at least be a choice that we're offering the applicant to make. Is that
Yes.
okay? So,
Do you want me to make that motion?
do you think 1 month is how long?
Yeah, would 1 month give you enough time to sort of?
Sure, but can I add something else? Even if I move that fence, I think I don't have any problem to park cars there. So if I park a car there, it's gonna, again, block the visibility. And I don't think neighbors can tell me don't park car there.
Right.
By law, I can do that, so.
Well,
I mean, it's gonna be, again, same thing.
I think that's part of the discussion that you
It
could
will
have.
cost me $2,000-3,000 to just do that, but I don't know. I can give that money to any charity that they want and get rid of things and keep that things there.
Well, I think
mean,
we're. Let me tell you where
because-
where I hear the conversation right now is that it would take 4 votes for you to get a variance today. I don't see 4 votes that would be willing to vote for that variance today, especially given the nature of the concerns of your neighbors. And so where it looks like it's headed, based on the discussion, is a deferral of either 2 weeks or 1 month, depending upon what you feel like you need to talk with the right folks. But that is to talk with the neighbors and the neighbors that are here, and maybe even send out letters, have a meeting, but to garner some neighborhood support of where that fence needs to be to alleviate the safety concerns they have, and talk it through. And if you come back with a proposal that folks agree with, then I think you may or may not get the support from the board. I can't speak for the board, but they would at least be willing to consider that where they wouldn't at all today. So that's where I think we are. Is that
Yes.
everybody
So,
nodding?
I would also I would be careful about assuming that if the fence is moved, you can just park cars out there. You may be right, but there may be laws about obstructing the vision of
I don't
traffic.
know,
So
maybe.
I don't know that I would make that assumption that. So.
But I think that so it sounds to me like usually a month is probably the most. That's a good way. And then I think in the past we have. Is there a need for a variance for a month to? I mean, there's not an issue with just deferring this for a month, right? I mean, okay. So is that your motion?
Yes, that was my motion.
There's a motion to defer this case 1 month for the applicant to work out some additional details. There's a second. Any other discussion? All in favor, say aye. Aye. We will see you all in a month.
Thank you.
Thank you.
Next case, 2019-358, involving property at 3530 Richland Avenue. Is the applicant here for case 358? Andrew Ford. Is there anyone here in opposition to case 358? He's not here.
Well, the applicant's not. And do we know the applicant did not agree with planning?
I actually have received notice that the applicant just recently received notice that they do agree to planning's recommendations. He had some confusion after the meeting started. He let me know. I'm not sure where he is, but so I don't know if y'all want to go ahead and move it to the consent agenda, or if you want to
If he gave you a verbal that he agreed with planning, that would have been on the consent agenda and it would have been passed.
It would have been, yeah, had he
So
given me the notice
and
prior to the meeting starting.
Planning recommends that he build a 2.5-foot grass strip and a 5-foot sidewalk along Richland, which was, and if they agree to that, I mean, I'm happy to move that we approve this variance.
That was the recommendation by planning, I believe.
On the conditions
Yes.
of planning. Motion second. Any discussion? All in favor? That passes. All right. Page 7.
Next case, 2019-365, involving property at 87 Vaden Drive. Is the applicant here for this case? Yes. Is there anyone here in opposition to this case? Are you here for something, for this case? Are you the applicant? Are you here for this case? Okay, you raised your hand, so you threw me off. Okay. Sorry, I apologize for that. So this is case 2019-365. This is a request for a variance from maximum building coverage for an accessory structure to construct an attached garage in addition to the existing garage. Before you was a zoning map showing the zoning of the property is RS10. Aerial photography showing you the parcel and its current conditions and buildings. This is the site plan that shows you the proposed garage as well as the existing garage that's on the property. And finally, the photograph showing you the current conditions of the property. Seeing no opposition here, the appellant will have 5 minutes to make your presentation. Please be sure to identify yourself by name and address.
My name is Philip Wade Farman, 87 Baden Drive.
All right, tell us what you're trying to do.
I'm trying to take my swimming pool. I've got an old concrete swimming pool. And I'm trying to turn it into a garage.
Okay. That's
weird.
Well, and yeah.
Well, if you turn back a minute ago, you'll see how nasty and dirty
Yeah.
it is. The pool is.
Right.
And
You're going to fill it in and build a garage above, right?
yes, sir.
Okay.
I'm cutting it in half, and I'm taking my walls up, or I won't have to go so high up in the
So tell me, the code, I think, allows you to have 700 and some odd square feet of garage space, and you've got a 576 square foot garage, and you want to add another 1,100 square feet. So you're going to be about twice the allowable garage space from the code allows. And so why do you need the two garages? And tell me, and then for a variance, we got to find a hardship. So help me understand what's the hardship that.
Well, I'm trying to take my like the pool out.
Okay.
But my dad left me some street rods, and my little brother kept them. Well, he's got sick and had to move, so now I have no place to keep the rods. And I've lived there, that house, all my life. And he built that swimming pool, and I promised my mama I would never do nothing with that pool.
Uh-oh.
So I'm fudging a little bit and trying to make we have no reason for a pool anymore. It's just a lot of work, and like I say, I got some street rods, some classic cars that my dad left me, and I'm trying to have a place to put them.
Okay.
And I collect some gas pumps, and I'm just trying to use that whole area.
We feel like a garage would look much better than an empty, not empty, but a swimming pool that's not used, and it's just, a stormwater catch-all and mosquito haven, and we haven't had any opposition from our neighbors that we are aware of. We have a letter from our next-door neighbor. We've had several phone calls from people surrounding us. We actually have neighbors that are here on a different matter, but they are not in opposition to it either. So it's just, we're asking for approval to build this detached garage and not have to attach it to our house, which we were told by codes we had to do, and there's no way feasible to do what they were telling us we had to do, which was to build a breezeway and connect the roof line from the house to the roof line to the proposed garage. There's just no way to do that.
What about just the idea of, can you expand your existing garage? I know that doesn't address our pool issue, but can you expand the existing garage and make it sufficiently large to house what you're trying to house?
Not without going into the space where the swimming pool is.
Okay, but you were planning to fill the pool anyway, right?
Right.
It just seems like you're building a lot of enclosed space. So I'm wondering, I'm just trying to think, if sometimes what happens is people will come and say, I need some storage area, but they will not do an enclosed structure. So I was just wondering if that's something that could work, if you had more, if your current garage were bigger, but maybe then you built a not enclosed structure. I'm just talking out loud. I don't.
With the vehicles, the antiques, they don't need to be in the weather elements. They need to be garaged.
Okay. All right.
You're not using the pool presently, are you?
No, sir.
It hasn't been used for a good 5 or 6 years, and it's just an eyesore in the backyard. I'm sure our neighbors would appreciate something.
And what is the current
nicer
garage
looking.
used for?
I do a little body work on gas pumps and,
Okay.
and stuff.
It's a shop.
It's a shop.
Yeah. Yeah. We fell down the steps last Sunday.
Any other questions? And you have a hard ask for us because it's such a large construction project in terms of,
Well,
17.
what if I cut 12 foot off of it? There's the blue part right there. That's 12 foot. So if I cut that off and just built it on the pool part, that would be 38 by 28.
How many vehicles do you have?
6.
I'm sorry, I can't do the math that fast.
It's less than 900. Something like that. 840.
So there's
38.
there's no opposition. I got a housing.
Is it 38 by 20? I'm sorry, what would the dimensions be?
38 by 28.
38, okay.
38 by 28.
Oh, they're 30, yeah. So, yeah, that's a house, yeah. All right.
I may not be understanding it right from this photo, but how would you get the cars to the proposed garage? Doesn't look like there's a driveway.
There's a driveway right between the house and that last garage right there.
There's so
I'm gonna
many
build a little
buildings on
driveway right
the
there.
Would come
property,
down
it's
the
hard to
driveway
see.
around the back of the house.
So that's a drive that goes around the house? That's not a sidewalk? That's an actual
No, that's the
drive?
sidewalk you're looking at. To the left of that sidewalk is the driveway that comes from the street, and it comes around the back of the house. Well, the driveway doesn't come all the way, but you can drive all the way around the back of the house,
Okay.
between the house and the existing detached garage.
So you drive on the
can back
grass
there.
and, okay. So is that a carport that's south of your house? Carport? And then what, it looks like there's 2 structures with white roofs.
That's 2 trailers that I've got some cars in. that
2
I've
trailers.
borrowed to
Okay.
keep these cars in till I get this garage built.
Will those trailers go away if the
Yes.
garage is built? Okay.
So you're in essence using the trailers in the little garage right there.
Yes, sir.
I forgot what the front of the house looks like. Can we see the photo of the front of the house?
Hey, Emily,
So are they lower? Is that what I'm seeing that's lower in that photo?
so does your driveway slope down?
Yes.
Is that so slow, so you don't see that? Okay. Any other thought or question?
No, I think you guys asked all the questions. I don't have any more.
Any questions? Anything else you'd like to add? All right. We'll close the public hearing. Thoughts?
I want to know what Ross says. I want to hear what Mr. Pepper has.
What's that?
I want to hear your thoughts.
I just don't see hardship.
I knew you were going to say that.
That's why you wanted me to leave. I knew I've been set up.
Yeah.
She knew I would leave. So.
Why don't we exile you down the very end, Mike?
Don't we you think it's a hardship if you got a bunch of street cars and you work on them and you need somewhere to put them and your neighbors don't care? Don't you think that's a little bit of a
the neighbors
hardship?
not caring always matters, but I think that it's not just, I view my job here as not just looking out for current neighbors, but looking out for people that may move
You're
there in
right.
20 and 30 and 40 years, and they may, they may want more zoning integrity, and I know it's not ideal to store stuff, away from your house. You want it close, but I don't think there's any shortage of places to store things, to rent and store things, and I can't find any hardship here, and we have to have that to grant a variance. So
Well, let me just ask this. We're just chatting. Because he's got the swimming pool, which to me may create a hardship, in addition to an eyesore, in addition to a health problem, does that affect your thought at all?
no, if it were
was
maybe a
his parents.
pre-existing structure and a foundation, it might, but the way I view the swimming pool is, if it's going to have to be dealt with, but it's not it doesn't create a hardship. It's just a swimming pool that's no longer needed.
Well, I agree with you on protecting the integrity of the neighborhood for future people that might move into the neighborhood. But on the other hand, if this is built, they'll know what they're getting into. They'll see it. If they want to move next door, they'll see this big structure housing the cars, and they can choose to move there or not. But so I see both sides. I don't like the trailers, personally, storing the cars, and it doesn't seem that there's any way to legally make the trailers go away. I don't know. I mean, I'm not in property standards, so I don't know about that. So I think the garage is a better alternative to the trailers. But, does this qualify as a hardship? That's something to discuss.
Let me guess.
I'm having a hard time finding what I appreciate. I don't mess with it, but you're going to have to string the large detached well that may at some point in time come back here because it turned it into something.
Mm-hmm.
I appreciate him wanting to keep vehicles, getting rid of the pool. Ms. Pepper sort of has my ear on this one, to be candid with you. I'm groping for one, and I'd like to help. I just can't find it.
Anybody?
They've got some more. I mean, the existing building now is 576 square feet, so they've got some room to go up to the 750, but it's just not, I don't think taking off a little bit of the pool is still not going to get you close to the 250.
Yeah.
So
His measurements, even if he cuts it, takes out the blue area, it's another 1,064 square feet. And if you take off the 250 he had, he still basically, it would be doubling
Right.
what is otherwise allowed. I see it.
Any other thoughts or emotion?
Well, I do have a question, trying to shout so you all can hear. This is a variance from maximum building coverage for an accessory structure, but there's another category of maximum building coverage that deals with, I think it's RS10, and they're only allowed to build, 50% of the site. I'm just guessing what the chart says. I'm just wondering if I know this answer is probably not known today, but if they did build where they attached onto the house, they might be able to actually be allowed to build more than if the structure was detached. Does that make sense? You alluded to it with your walkway. So I would be curious to know, and I realize you all don't have that answer, about how much they are actually allowed to build on this site.
That could very well be the case, and that is sometimes the case. It's not what's before the board today, so we
Right.
don't. And if they want, that's something we could look into if the board's inclined to defer this, so that we can do that. If they have a specific project or plan they want us to consider along those lines, but we reviewed what they submitted, which was the detached garage.
So is your point, I think, is if they would be allowed to build this structure if it were attached to the house, could the hardship be the inability to attach it to the house?
That's one way to look at it. I would be interested in the comparison of what's
because of this topography or whatever.
There
it
could
doesn't
be
line
some
up.
hardship in
All right.
that. Yeah, I'm chatting. Just trying to offer you all some ideas. Maybe if we deferred it, you all can investigate that.
Well, we did investigate that already, and there's just not any
I'll open
feasible
the
way
public
to
hearing.
attach it.
Yeah, I'm not saying you would necessarily have to attach it to the house, but I'd be interested in hearing the comparison that if you were to attach it to the house, how much square footage would you be allowed to build? Does that make sense?
Do you know that
One person told
answer?
me that we have if we put a breezeway from the house to the garage, it would be okay. Well, then you turn right around, the next person told me that I had to have it concreted and 4 walls. Well, if that's not a breezeway.
So that's adding even more structure and more impermeable surface.
Any other questions for that? Since I will close the public hearing again. How to proceed? Defer?
I'll move to defer, if the applicant wishes to defer, to bring us the additional analysis.
One meeting?
Oh, I'll second the
Thanks.
deferral
One meeting.
motion.
One meeting.
Yeah, the motion on the table is to defer. We can take a vote today. I doubt you're going to pass today based on everything that you've seen and heard, and I've seen and heard. So this, in order, basically out of respect for the applicants, when we see that there might possibly be a path to allow this, we say, let's defer it, get additional information. The additional information that I think that you were looking for was, what is the maximum that you'd be allowed to build on the property were it all connected? And is that the only issue, is the ability to connect, and then maybe even understanding a little bit more the topography of the distance between where the pool is and where the house is, and how it may or may not be difficult to actually connect the property. So if you can find that information over the next 2 weeks, we'll hear this again in 2 weeks, provided the motion passes, which has a second. And any other discussion?
I do. I have a point for them. It would be helpful to have photos of your backyard showing the area.
Any other information that people would like to have? Okay, all in favor of the deferral, raise your hand. Any opposed? We'll see you again in 2 weeks, and good luck. Next case.
Next case, 2019-367, involving property at 1812 A and B Beach Avenue. This is a request for a variance from roof pitch for an accessory structure in order to construct a detached garage. Before you is the zoning map showing the zoning of the property is R8. Area photography showing you the property and surrounding areas. Site plan submitted by the applicant. And finally, the photograph showing you the current conditions of the property. Is there anyone here in opposition to case 367? Seeing none, the appellant will have 5 minutes to make your desired presentation. Please be sure to identify yourself by name and address.
I'm Jeff Harrington, and I'm the owner of these properties at 1812A and 1812B Beach Avenue. And I would like to construct detached garages, and these are currently under construction, by the way. I'd like to construct detached garages behind these homes. And as it applies to my property, the zoning code addresses building height, and that accessory structures located to the rear of the principal dwelling may have vertical walls rising no higher than 16 feet from the side and rear setback lines. The roof on the structure shall rise from side walls no greater than the predominant roof pitch of the principal dwelling. And I would like for the detached garages to have gabled roofs, which would be characteristic in appearance to all of the other detached garages located along this section of Beach Avenue that runs from Wedgwood to Argyle. And following the guidelines of the zoning code and considering the flat roof pitch of the principal dwelling, the roof I would be allowed to build would have a minimal slope. It would have a rubber roof membrane versus shingled roof covering, and it would have a very minimal slope to it, and it would be very uncharacteristic with all the other garages, detached garages located along this section of Beach Avenue. And I believe the building height code restricts me from having a gabled roof with similar features, accommodations, and amenities currently enjoyed by my neighbors. And as such, I'm asking for this building height variance. And you see the pictures of the house. The building height of the house is 38 feet. The proposed drawing of the detached garage is 23 feet 8 inches. And I would also like to say that the zoning examiner, when they looked at that, they're basing the predominant roof pitch on the flat roof. When you look at the house from the front, you can't see a flat roof. You see a mansard roof. And so I'm not sure, but anyway, that's what's got me to this point of trying to get this variance. To me, I don't see it. If I said go to the house that has a flat roof, I don't think I would end up at that house. But anyway.
But you built that house, right?
I'm in the process of building it, yes.
And you chose the design, you chose to have the structure like that, right?
Absolutely, and I did it. I'm actually a contractor, but I'm moving in this house.
Right.
And so I did it because along this stretch of Beach Avenue, there's several houses that were original to that time period when it was built, I guess back in the 30s and 40s. And I could have built a modern type house where you could, when you look at the house from the front, see a flat roof. It would have been a lot more cost effective for me to do that. But I chose to build this mansard style roof so that it would blend in better with the houses along that street. And so that was the reason for doing that. And so anyway, I wanted to make note of that. So the ruling that determines the pitch of my garage roof is based on a roof that you can't see. So, that's a point I'd like to make. But where it creates a hardship for me, this height limitation, is that it keeps me from having a garage with a gabled roof that's characteristic of the detached garages located on both adjacent properties and lots next door to me, as well as the remainder of all the detached garages located along this section of Beach Avenue. And the garage I would be allowed to build, following existing building height regulation, would be uncharacteristic in appearance when compared to the existing garages located along this stretch of the Beach Avenue. I would also like to have the gabled roof because it would help block the rear elevation, or the rear view of the retail establishments located across from the alley. And they typically, it's a commercial area, I understand that, but there's a lot, probably 10 or 12 trash receptacles out there all the time. And so this garage, when I look from the house back to the garage into the rear of my property, that would block that view. So without having the gabled roof, I wouldn't be as able to block that view. And then also, it restricts me from having attic storage space.
So, Mr. Harrington, I'm sorry.
Go right ahead.
I think what you're doing, I think it's a beautiful design.
Thank you.
But what I'm struggling with is assuming that there is a hardship. How is it not a self-imposed hardship? Because you selected, as I understand, the design of the main house with the flat roof. So it seems to me like when you did that, you boxed yourself in under the zoning code, and to me that just seems like a self-imposed.
Right. Well, it depends on. To me, when you look at the house, the front elevation of the house does not show a flat roof. It's a mansard roof. It has a very steep pitch to it. And so you're not seeing a flat roof.
So you're saying you think the pitch should be what's facing us, not what's...
I think when you're talking about what's the predominant roof structure, which is the strongest, the main element of the home. When you look at that from the front, you see a mansard roof. You don't see a flat roof. And so based on that, I think it's very limiting to say, well, your garage that you're going to build back there has to have a flat roof and can be no higher than 16 feet. So I think that's limiting.
And I guess codes determined that it was a flat roof. So did you argue this point with them?
I didn't argue that with them real strongly at the time.
What's that?
Because I didn't argue that at the time with them. Because when I looked out there, I said, well, they're going to probably, assume that's predominant roof pitch, because the majority of the roof is flat. But in thinking about it after the fact, the fact that the predominant roof is not the flat roof. Predominant doesn't mean it's the majority of the roof or the biggest part of the roof.
You're
it's
saying
what
predominant
you see.
means what you see.
It's the strongest visual element of that house when you look at it. When you, in terms of determining the predominant, the pitch of the predominant roof. So that another thing too is, if I can build the flat roof in the back, but it's not going to be characteristic of all the other detached garages there. There are 12 properties, I think I counted located up through there. 8 of them have detached garages. None of them are flat. All of them are gabled. One of them is hipped. So there's not a flat. I'm wanting to do just like I put the mansard roof on the front of the house to make it more consistent with the other houses along the street. I'm wanting to accomplish the same thing with the garage, in that if it has a gabled roof, it will be consistent and characteristic of all the other garages located along that stretch of Beach Avenue. And I mean all of them.
You've run out of time, so let me ask you a question. I'm having trouble reading your drawings that were put in our packet. It's not legible. But also, it's not shown on the garage. So what is the height from the eave on the garage to the ridge?
23 feet 8 inches.
I think that's your total height.
That's correct.
I'm talking about the eave, where you put the gutter. Approximate that area.
It'd be right around 10 feet.
10 feet, okay. So the mansard roof, how tall is the mansard roof on your principal dwelling?
It is
9, so
10,
it's
10, 11, 8, 14, 8. It's a little over 15 feet tall.
okay. So the mansard roof, the height of the mansard roof is about 15 feet tall, and the height of the proposed roof for the proposed garage is about 9. You said 9 or 10.
That would be. It's rising from the
just approximate.
From the E, yes, something close to that, yes.
9 or 10,
Yeah.
around that. Okay.
But overall, the house is 38 feet,
Mm-hmm.
and the garage is 23 feet.
Okay.
And I have drawings of that if you'd like to see the garages.
We can see them to some extent. It's
Okay.
just blurry on the screen.
And we get the numbers came out
Okay.
blurry. We can see the design, but we can't read the numbers.
Correct.
Any other questions?
This isn't your first property that you built, right?
No, I've been building houses since 1994.
So you knew this might be an issue when you were starting?
Yes, I did.
Zeroing in on
Yes, I
what
did.
Mr. Pepper
But
did.
I also know that others have come and had variances on these types of accessory structures too. And I think the ruling, as it is, was not intended when it was written. Probably they didn't consider that some principal dwellings might have flat roofs. It just doesn't address the issue, and it puts us in that situation where I think it creates those hardships.
All right. Any other questions?
So there's on the gabled the garages you're proposing to build, is that going to be from the eave to the ridge? Is that going to be storage space or?
That would be, yes. A portion, even with the depth of the garage is 24 feet. So even with that building height, you'll be limited in storage space, but it would be of some help.
It'll give you more storage space than if you had to have the flat roof.
If they have a flat roof, I'll have 0 storage space.
Okay.
Any other questions? All right, we will close the public hearing. Thoughts?
Well, I understand the point he's making, in my own way, I guess, in my own analysis.
Our architect on the board.
Thank God we've got someone who understands.
So I don't actually I have more of an issue with the roof of the garage is not going to match aesthetically to the roof of the principal dwelling, but we're not here to judge that. But I do see how the flat roof of the principal dwelling, that's not really what was intended to be looked at. So I would be in favor of granting the request.
Can you speak up, Mike?
It keeps looking to be self-imposed, and I'm finding the hardship part of the change that wasn't put there. I mean, aesthetically, what he wants to do is a whole lot better, probably. But he went into it knowing it. And that, I'm not saying I can't be convinced.
I don't disagree that he knew, and he acknowledged that that was an issue, but I tend to agree with Christina. The point of it is it is a design, and when you look at the house on the street, it doesn't look like what we think of as a flat roof. I mean, so to me, it does make sense that the garage would match the house. I don't think it is. It's different than somebody coming in saying, I want to build a bigger structure. I knew this was a small lot, but I want you to let me build a bigger structure. To me, it's more just an issue of having a consistent design on both of the garage and if we have the garage, it's going to keep the cars off the street. I mean, so I tend to think I could be convinced to grant it based on what he's asking for. That's just my thought.
Well, I'm definitely not an architect. That probably shows sometimes. But if you ask me what kind of roof that was, I'd say that was a flat roof. And I think the point of the code is that, and I appreciate what the applicant is saying, is that the garage will be more consistent with neighboring properties. But I think the point of the code is that you want to have your main structure consistent aesthetically with your accessory dwelling, and I do think that it is assuming that there was a hardship, and I don't know that I see the hardship. I see that the applicant wants to do something that may be more consistent with neighbors, but assuming there was a hardship, I do think it is self-imposed, and I can't. That's just where I am. So.
I really wish that you were right that the code intended for things to be aesthetically pleasing.
I could be wrong. I should say that's an assumption
I wish I could read
make.
the code excerpt, because I doubt the zoning code is cares about whether or not it's a mansard roof versus a gabled roof. But I wish it did. But I think the issue at hand is the height and the pitch of the roof. But I don't know. I wish you were right, because it's not going to really match very well. But I don't have that code excerpt to
So
look
you're
at the
thinking
intent.
the issue, in your mind, the code, well, what the issue is proportionality, height and
Yeah,
proportionality
that's
of
a good way to say it.
garage to the main structure.
Yeah.
But the codes, but I get that, but the code specifically is referring to the pitch of the roof here. It's that's what the issue here is not really the pitch. I mean, not the height. It is the pitch. I mean, that's in the code. It's the pitch.
Yeah. But
Well,
that
you see a flat roof, but you also see.
I
there's
agree
a
with
bit-
that, and I think you did a good job of pointing that out. But but to me, it's still a flat roof with essentially a facade that is kind of
A shingled third story.
yeah, kind of a design feature.
A facade? You're talking
A
about
facade,
the facade?
yeah, I guess.
So
Again,
can you open the public hearing so I can ask him one question?
I'll
Is
reopen
that
the
okay?
public hearing.
Your mansard roof, is that shingles?
That is shingles.
Okay, thanks.
It will be
That's all we
shingles.
need. Thanks.
All right, close the public hearing. All right, any other thoughts or emotion? See where we are.
I can't blame him for not wanting to look at dumpsters. I drive by that area going home every day. I mean, I know the area. I'm going to my cohort up the other end this time.
Well, can I ask the codes department a question? Would he be allowed to build a mansard roof on his garage?
Without reviewing it, I think so, but I haven't reviewed that specific question.
Can I say something there?
I'll open the public hearing and you can ask the applicant.
Oh,
Would you build a mansard roof on your garage? Why haven't you told
well, I
us
would
about
only have
that?
16 feet in height to build it, so you couldn't do much with a mansard roof. Roof was 16 feet.
Yeah, I thought it was to the eave.
No, the building height says the walls can only be 16 feet tall.
So
I'm
they're
limited to
considering the
16
mansard
feet
roof as
because
having a wall?
they're interpreting they're making me have a flat roof from the top of the 16-foot walls because it has to be the same as the predominant pitch on the house, which is 0. So the code says I can go 16 feet with walls, but with the 0 pitch, I'm going to be topped out at 16 feet. So that would be the tallest I could build it if I, at this point, without a variance.
So is the downside to doing it the way codes wants you to do it that it doesn't match with the neighbors? Is that the only downside?
That to me is the main thing. When I went to great length to make the front of the house try to match with the street. And so now as I look at the garages along the back side of the street where they have those, what I'm proposing to do is matching and blending in and being consistent with those structures. I did the same thing on the front of the house. Now I'm trying to do the same thing with the garages in the rear.
So
if I build a flat roof, it's going to look, I'll be the only guy on the street with a flat roof.
So you're just saying the way that you've received the interpretation from codes is that what we see in black up there is not really roof. It's considered a third story. The roof is what's above that, and it's flat.
That's correct.
So you, even though there's an eave that we see on the third, would that be considered an eave?
The eave, I brought
Well,
you
no,
all
right.
the
I'm talking about that thing right there that we see.
The white,
Yeah, I
the
understand,
white
but I'm talking about
horizontal
the front of the
boards going
house.
across there, that would be typically cornice or eave.
That's what you would consider it, but that's not how it's being viewed.
Yeah, that's and
If you had a
thinking about
garage-
it after the fact, I'm looking at it and I'm going, that's when you look at the side, you see the mansard roof. That's an architectural style. It's not something I created. That's a roof, and it has a pitch to it. And if that's a predominant pitch, it's running about 24 inches every 2 or 3 inches it moves in. And I'm not proposing to do that at all, but I think, and like I say, when I applied for the permit for the garage, I didn't take issue with that at that time. But in thinking back on it, since that time, I'm going, that is really, like I said, if I told somebody to go to the house on the right side of
we
the
understand. Let me just ask you one more question really fast.
Sure.
And I don't know if we'd be allowed to do this, but if we granted you a variance to build a mansard roof on the garage, would you be agreeable to that?
No.
You don't.
That's
roof.
not the point. That's not what I'm trying to get to.
Okay.
And that would not be consistent with the other garages located along the street. It would be
But it would be
garages
consistent
that are
with your
within
home.
20 feet of my property line.
It'd be consistent
have
with your
gabled
home.
roofs.
Okay, I'm okay.
But okay, and that's the downside, and that's the hardship you're relying on, that it won't match with the neighbors, right?
That's one of them. And just the fact that because the code itself is not applicable to flat, I don't think it was ever written with the thought that principal dwellings would have flat roofs.
Well, but
And therein lies the opportunity to come and try to get a variance.
But you're asking us to make an assumption about that, about why the code was written when the code clearly talks about the pitch, the predominant.
Well, I guess so. But I mean, I could do a roof I could do walls 16 feet, then I could do a slope at 1/4 inch per foot, and it would look hideous. And you would be wishing, but that would be following the code to the T at that point. But that's, you know, and I'm just really wanting to do something that's consistent with the property. I don't want to be the guy on the street with the white elephant that's going, you know, that everybody's going like, why did he do that, you know?
But I mean, this is the only, is there another mansard roof on the street or next to you? Or it looks like the
Within that
property-
general area they are, yeah.
Because what I'm seeing is there's no other mansard
Right.
roof, so you've already got your principal dwelling doesn't match with the neighboring properties, but now you want the accessory structure to do that.
Well,
That just strikes me as kind of odd.
The mansard roof falls more in line with houses built in that era than it would have been if I had built a typical trendy modern house, sugar cube type house that you see built today.
Look up the code.
So so I went to great expense to try to do something that I felt like blended with that neighborhood. Better than anything else I could do.
I think the design of the main structure is very nice.
Thank you.
And I commend you on that. I don't see the hardship. And I think if there was one, it would be self-imposed.
All right, any more questions?
Yeah.
Well, unless,
We'll be here all day.
all right. No other question for the applicant? We will close the public hearing. Okay. Thoughts or motion?
I'm trying to read what the code excerpt says.
I mean, I don't really have, I do think that there is a dilemma the way it's presented. You know, and I don't want to take a survey of the crowd, but if you ask, my gut says if you ask what's the roof and what's not, you'd get a lot of different thoughts. And I was disappointed in the answer that to Christina's question about, you know, if you had a variance to basically do the same roof on the garage, and the applicant said no, he didn't want to do that. That to me would be the obvious solution, because it would basically say you got the same thing and you're still restricted by height, but we'll just consider that to be the garage. But I mean, clearly he's got a design of the garage in mind that he wants to do. I don't really have an issue with the garage. I think the garage is, as drawn, is better than the flat roof garage, but I think that if you wanted to just be completely consistent with the code, if you had the same roof on, type of roof on both, and kind of the one hardship begets the other, and say, well, no, they have the same slope because they're the same roof. You know, it's kind of hard to argue that. So, you have a motion to deny the variance?
Deny the motion.
Second.
All right, there's a motion to deny the variance. There's a second. Any discussion on that motion? All in favor of that motion, raise your hand, say aye. All right, 3. Deny. Opposed? All right, that motion passes 4-2. Next case.
So that's denied.
Yes, sir.
Okay.
Sorry.
Next case, 2019-368, involving property at 625C Rees Avenue. Is the applicant here for this case? Yes. This is a variance request from the minimum lot size requirement. Before you is a zoning map showing you the zoning of the property is R8. Aerial photography giving you a sense of the surrounding area. Site plan submitted by the applicant, and finally the current conditions of the property. Is there anyone here in opposition to case 368? Seeing none, the applicant will have 5 minutes. Please make sure to say your name and address before you make your presentation.
Hey, I'm Jeremy Seaton, address 109 Spence Lane. This is a legally created lot back in 1962. It is the only lot on Rees and Waco that is less than 8,000 square feet. I have 7,884 square feet on the lot. I'm 116 square feet short.
How did you determine it was the only one that had less than 8,000 square feet? Because when I was reviewing the consent agenda, that was the question I had. And when we have cases that are, frankly, this close, I'll look at what are the other lots. And I looked at that with the code staff, and we determined that the 3 houses to the right, of the 3 houses to the right, 3 houses to the left, total of 7 houses, only 2 were over 8,000 square feet. So what is your data that says it's not? And across the street, it was about 50-50. About half of them were over 8 and half of them were under 8.
You're exactly right.
So why did you just say that
I misspoke.
there were two streets and this was the only one? I mean,
Completely misspoke, and I apologize. Out of the my intention there's a large number of duplex dwellings up and down Rees, Waco, and again right behind us on Rees as well. When I go back through those, we are the only one of those duplex lots that are not of the full 8,000 square feet. 625 Waco is 7,900 square feet, a difference of 96 square feet. 614 Waco, these are all HPRs that have already been built and sold. 614 Waco, which is just on the street over, that's 7,884 square feet, which is my exact size, but that project was built in, I believe it was 2017. So that one kind of slipped through the cracks or was previously approved. 603 Rees Street is 7,250 square feet. That was also approved for a duplex. That's a difference of almost, what's the math there, 800 feet. I'm less than 1.5% short of the required 8,000 square feet. And our plan, of course, was to build two very nice homes that fit into the context of the neighborhood. And we are asking for the variance to forgive my 1.5% shortage on the lot area.
so back to the your original comment was that it was the only one, and you said you misspoke, and I'm not sure exactly. Then you, what were you?
I absolutely misspoke. Out of looking on Parcel Viewer, when we look at the duplexes that are currently built, there are on the right side of Rees, I believe on the east side of Rees, all the way down. You're exactly right. The bottom half, the north side of Rees. You're exactly right. We're all in that 7,000 square feet range. A case that was just heard earlier on Laramie. That's the corner of Rees. I'm very familiar with that property as well. And I apologize. I got nervous and just completely misspoke. I'm not a great public orator.
Any questions? So, and the specific hardship is you're close but not quite there? Or is there another hardship?
Yes, sir. I'm less than 1.5% to have the 8,000 square feet. That's really about the size of one car. The lot just to the left, 4 to the left of me. The width of my lot, I believe, is exactly 54. His is 55, and that pushed him over. Mm-hmm. And literally a foot in either direction would make me look just like everybody else up and down the street.
Okay. Any questions?
We would have, of course, sidewalk eligible, or well, we would need to build sidewalks there. I don't have the permit, of course, now, and I believe as of yesterday, the sidewalk regulations changed quite substantially. That would be something that we would pose back to the neighborhood association. If they wanted us to build sidewalks, we'd be happy to. I think we would be the only ones on Rees. I have 2 NES poles very close to the property. After speaking with NES, they're going to make me put those poles back on the property line, which would eliminate a little bit of a tangled mess there. And of course, we have to go underground with our power back over to the house, which would alleviate that sight line.
Okay. All right.
Did you have a formal survey done? I didn't see it
Yes,
in the
ma'am, I
packet.
did.
Did you submit that to us?
I did not.
Do you have it with you?
I do on my computer. I'm happy to pull it up.
But it did show the 54 feet, the
Yes, sir.
7886.
Okay.
Okay. Well, and that was, again, I mean, I already explained why I didn't put this on consent. It basically was because and there were some that were on consent, but that's because they were, and they were close too, but all of the properties were exactly the same size, and it looked like a surveying error. In this case, all the properties were not the same size, but were consistently short, you know, a few, with a few exceptions. And so I thought that that was something that the board,
The majority of the
that the board should
shortages,
hear.
and again, I don't hold this to be truly factual. The majority of the math that I did from going north, Upper East, back towards the backside of the nations, those were all 200, 300, 400 square feet short. They were substantial, if I remember correctly.
Okay. All right. Anything else to add?
No, sir.
All right. We'll close the public hearing. Thoughts?
Well, we don't ever thank you for all the work you do on the consent agenda, so I really appreciate
Yes,
all the
thank
effort
you.
you put into that. Thank you. It takes a lot of your time that we don't hear about. And thank you for
Wow.
investigating that and giving us the opportunity to hear it.
Well, that was just in part to let you all know what my rule of thumb is for some of these too is, and it goes back to that one case that we
Yeah.
had that you made the point. Does this allow the applicant to have what the neighbors
Right.
have, and because their lot is a little cattywampus, or does it give them more? And in this case, it was kind of 50-50, and a lot of the neighbors, two of the neighbors were over on the same side of the street, again, going 3 houses over, 3 houses either way of the 7, and the other 6 were exactly the same size, 78, 86. And it is absolutely true that it's 1% off, which is really, really close.
I think those are typically cases where we have granted variances in the past with that kind of small percentage. But I do think it puts us in a position that if the other neighbors come in, we put ourselves in that place.
And
So-
we've denied them because in one case we denied it because it
Right.
allowed that neighbor to have what the other
Something
neighbor,
different than
which
the
they
other
clearly
neighbors have.
wouldn't have, and they weren't close.
Yeah.
This was the one neighbor that was close in the denial. So again, it was gray enough for me to send to you all. Well, it's going to go to y'all anyway, but.
And can you tell me, was it the ones that are
I just
directly-
asked Emily to say, because we were under the premise of does this just allow this applicant to have what the others could have? And I said, well, look at the 3 on the same side of the street, the 3 on each side, so a total of 7 houses.
Okay, one's across the street.
And it was determined that 2 of the 7, not including this one, of course, or it wouldn't be here, were 8,000 or more, and 5 of the 7 weren't. And then I said, well, look, what about across the street? And we didn't do the exact numbers, but we said it looks about 50-50. So maybe a little higher percentage of eligible across the street than on that side of the street. So again, it's it may be a case where half of these houses get it, and that may be that may be enough to say a hardship on the other. You have some that are 8,100 square feet and some are 7,800 square feet, and that may be where the difference is. It's 55 instead of 55 and 54 versus both of them 54 and a half. And if it was 54 and a half, we probably wouldn't be here. So maybe dividing it up, it caused the hardship here in terms of going to full feet on the lot size instead of partial footage. But again, it was gray enough for the board to hear. So
Yeah, the only thing I'm looking at on the aerial is in the neighborhood, there are some,
it's turning.
yeah, there are some, what do I want to say, 2 on 1 lot.
Yeah.
So-
Yeah.
Yeah. That's my only, and I'm not a fan of HPRs at all, but I just see some of them there.
So in terms of, you got all the facts, what are folks thinking?
I think whenever you're within 5% and certainly within 2%, just to me, that's that's so close that I think there needs to be something overwhelming to deny it. I also think that probably that considering surveyors base their work on, pins sometimes that have been in the ground for years and old deeds, I would bet that 1.5% is may well be within the margin of error for a survey. And so, and I also think that that where we can allow people to achieve density and maybe more affordable housing as a policy reason is a good thing. So I would be in favor of it.
That a motion?
Sure. I move we approve the variance. Grant the variance.
Have a motion, have a second. Any other discussion? All in favor of the variance, say aye. Raise your hand.
Aye.
Any opposed? Good luck. Yeah, we're going to take a quick break.
That was great information, though.
Quick break.
Photography giving you a sense of the surrounding area. This now is the site plan submitted by the applicant, and finally the photograph showing you the current conditions of the property. Is there anyone here in opposition to case 370? Yes. So each side will have 10 minutes. Please make sure you state your name and address, Mr. Hargis, before addressing the board, and then we can proceed.
Good afternoon, ladies and gentlemen. Joey Hargis, 211 College Street. We're here today requesting special exceptions to street setbacks. This site, Ms. Knight, could you put back the site plan? As you can see on the site itself, it's basically completely asphalt today. It's formerly a gas station and a plumbing company, I think was the last use. Our proposal are to build these 14 units that you see here with rear-loaded garages on 5 of the units and then the surface lot for the remaining units, 9 units. What's partially driving our special exception setback is the right-of-way dedication mandated by Metro of 14 feet on Porter and 7.5 feet on Riverside. Our setbacks, we are Zone CL, commercial limited, so our setbacks are required to be 15 feet. Obviously, with the dedication of 14 feet on Porter and 7.5 on Riverside, are being mandated by Metro, but the plus side for the area will be the installation of code-compliant sidewalks, which currently do not exist at this intersection. As you saw in the photographs, this intersection is an open ramp, and folks are currently parking in the right-of-way, at least on the Porter side, and I didn't notice any on my visit for the Riverside Drive. But I think if you look at some of the aerials, they are.
So you're not adding, you're allowed by code for the 14 units?
Yes, sir. Yes, sir. There's not a density issue like you have in RM type zoning. Right. And we are, and I've talked to Ms. Katie Tate. She's here opposed. We had a chat before the hearing. I'll let her address her concerns. But one thing we talked about was the overall height of the structures. We're going to be compliant with the height restrictions. Those height restrictions are 30 feet at the setback and then a 1.5 to 1 slope. So for every foot away from the 30-foot mark, you can go up another 1.5 feet. These units, and principally we talked about the ones closest to her, would be 2 full stories and a 3rd enclosed story with a rooftop patio deck type arrangement on those. We went to the South Inglewood Rosebank neighborhood meeting on August 22nd and met with 5 to 6 neighbors. No general opposition there. We showed them the plans here. We actually have a better colored, marked up drawing. We'll be installing a landscape buffer along Miss Tate's property boundary. That's fine, but that's basically all I had. Our requested setbacks would be 0 on Porter and 5 foot on Riverside from the 15 for each.
And that, and the planning department had recommended approval, and then that also is in consideration of the right-of-way that you discussed earlier.
Yes, sir, it is.
Okay.
That actually takes into account the right-of-way, and you guys should have. I received an
email.
email.
I'm sorry, you all are installing the sidewalks?
Yes, we are.
So
yes, 8-foot sidewalks on Porter and 6 foot on Riverside. Again, currently it's just an open ramp with no curbing of any kind there. And you guys should also be in receipt of the departing council member's support email, Anthony Davis. At least he emailed me, said he had sent a letter to you guys.
Okay.
I don't know if you have it, but doesn't matter now. He's off the council.
Right. All right.
No, that was not a shot at Councilman Davis. He's a very nice man.
All right, great. Any other questions or anything to add? All right, we'll hear from the opposition, and then you'll have 7 minutes and 10 seconds.
Thank you. My name's Katie Tate. I'm the owner of 1703A Porter Road. It's the property that sits directly behind 1527 Riverside Drive. Before I read my statement, I have a signed neighbor's letter that I'd like to share with the board. Can you pass that out?
Oh, thank you.
Thank you.
Mr. Hart just mentioned we did have a chance to speak, so I was relieved to hear some of the plans. I unfortunately missed the neighborhood meeting that he mentioned, but I wanted to draw your attention to several of the concerns in the statement provided. It was signed by 12 neighbors of the Riverside Porter Road area. The statement reads, "We, the undersigned residents of Riverside Drive and Porter Road, oppose Baker Donaldson's appeal for a special exception for the property at 1527 Riverside Drive, granting a special exception and thus allowing the construction of a 14-unit development would irrevocably change the architectural character of the neighborhood. Furthermore, granting such an exception would compound the neighborhood's growing parking and roadway congestion and would detract from a pedestrian-friendly streetscape. The requested exception is in contravention to City Code 1712-035D and 1712-060F3. For these reasons, we're asking the board to reject the special exception. Again, as I said, we've had a chance to chat since we came in. I do feel that while I'm relieved to see that this is not a huge structure, I am still concerned about these two areas of code that I mentioned, specifically 1712-035D, that it shall, in point 2, that the structure shall not create an adverse impact on adjacent properties or detract from a strong pedestrian-friendly environment. I understand they're planning to install sidewalks, and while generally I think neighbors would be supportive of that, we have such a huge parking congestion problem already on the street. I'm concerned about anything that would remove that parking area, street parking that Mr. Hart just mentioned. Already that section of Porter Road receives a lot of congestion to the point where we are concerned that emergency vehicles may have difficulty coming through there. It's a main artery into South Englewood for fire trucks and ambulances. I also continue to have concerns about Code Section 1712-060F3, and that is that the applicant shall provide evidence to the board that the proposed building height shall not create an adverse impact on air, light, shadow, or wind velocity patterns due to the configuration of the building. Again, we had a nice chat about that. I think the 2 stories was reassuring. I'm concerned a little bit about the mention of the 3rd-story deck area, and that may create an adverse impact as stated in the code. Thank you.
Thank you.
What's that? Where are you? You're on this. Well, you're not. You're
Sure. If you could show the map again, I'll be happy to show you. So my house is directly behind on the Porter side. So if you're on this map, it's just to the right of the property.
Right. And is that north of the property, south of the property? Do you have?
Without seeing a compass, I'm happy to point to it if it's confusing. Yeah. Is
it the house that
yes,
says Riverside?
Yeah, it says River. It's the house that says Riverside over it. On
right.
This. Yeah. Mm-hmm.
Okay. Anything else to add or any questions? All right, we'll hear from the applicant. Thank you.
How many of the matters have been remedied that are in the letter by the neighbors? And I'm sorry to add that Mr. Hargis
Sure.
covered that again.
I do think, I think adding a sidewalk along Riverside is a wonderful idea, and I think that would be helpful, again, to making the area pedestrian friendly. I'm concerned about the sidewalk on the Porter side, as that is where we still have that parking and roadway congestion. So I would say that portion of the concern, but again.
I mean, but now, you're saying that, how would building a code-compliant sidewalk negatively impact congestion?
Sure.
I mean, because this is like this is, from what I heard, this is the Cadillac of sidewalks. I mean, this is everything that the planning department dreamed the sidewalk should be. So how is that bad and make it less pedestrian friendly?
If I could ask you to turn to page 7 of the document I gave you. It's more to do with the problems, compounding parking problems in the area. You'll see, this is a shot of Porter Road. Because of parking congestion, people park largely in the road already. So I'm concerned that would compound this issue.
Right, okay, I still don't have any connection between, because they're not doing anything to the road. I mean, are you talking about the density, or are you talking about?
Density, yes.
Okay, so it doesn't have anything to do with the sidewalk. The sidewalk doesn't have anything to do with the density. I mean, I'm trying not to be argumentative. I really thought that that's what you said, and I don't get that. I understand that 14 units impacts density. I mean, they have a right to do that, and I understand that you'd rather have the parking lot, but you can't force a building owner to keep a use.
Not.
I mean, and again, and not that I wouldn't want that too. If it were my, I'd get all of those things you're saying, but I do want to understand. Like you said, the density. And I don't go down Porter Road much, but I went to an event on Porter Road and I parked on a side street 4 blocks over. I understand your parking issue, but I just don't know how the sidewalk ties to it. And I'm trying to understand this, and not being argumentative, really, truly trying to understand.
Oh, sure. Again, without having city code memorized, but my concern right now is, I guess thinning the size of the roadway. I don't think I'm using the correct term there, but there's no curb there at the time. There's no curb there currently.
Yeah, they'll be required to do that. But you're saying the addition of a curb, basically people are driving on areas they shouldn't be, and that's not a bad thing.
Yes, and this may this may be also a city planning issue, which is again another reason we wanted to bring it to your attention.
Okay. That makes more sense. I understand that now. So basically, if people were doing exactly what they're supposed to be, it wouldn't be connected, but because there's
if
not.
only they did.
Right.
Yeah.
Well, there you go. All right. Any other questions? No. I appreciate it. Thank you for the clarity.
I had a question. You mentioned the code section about like height and affecting like wind, air, that particular section. Could you talk a little bit about how you think that would specifically be impacted by this development?
Sure. So most of the structures in the area are single-family homes or townhomes with, as of course, with the exception of directly across the street is a mixed-use area, which have been put into 2 historic buildings there. My concern is that the addition of these decks that are proposed will add a level of, make these structures taller than most of the existing structures in the area.
Thank you.
Mm-hmm.
All right, Mr. Hargis. You have 7 minutes. And
Thanks, and thanks again for Ms. Tate talking with us before the meeting. One thing I'm kind of take a little bit out of order. The section she cited, 1716-060F3 on the height, it's not applicable to this request. We're not requesting any height special exceptions or variances thereof. We will be compliant with the code. The zoning code, this parcel, Ms. Lamb, does it have a zoning map? I'm trying to recall if so our parcels is zoned commercial limited, which permits a 30-foot height at the setback, and then for every foot you step away from that, you can go up another 1.5 feet. So we're not in any way asking for this board to grant special permission for any additional height. We're not already allowed to do so. So
Yours is just a street setback.
it's just a street setback. So kind of taking that off of their request. That on the street setback side, and I appreciate these pictures because this actually illustrates my point a little better than I attempted. And this parking is right along Porter Road. This is page 6 of her supplement. This is exactly what we're eliminating. This is going away. We are widening the right-of-way. We're widening the street 14 feet here. So the ultimate goal for planning is to ultimately get from what I understand, either a 60 or a 70-foot right-of-way on Porter. Strangely enough, Riverside, although you've got the divided median, it's actually an 80-foot right-of-way. That's wider than some parts of Old Hickory Boulevard in this county. And we're dedicating another 7.5 feet on Riverside.
Can I ask you a question
yes,
while
certainly.
it's on my mind? So because you're dedicating right-of-way to build the sidewalks, that's moving your property line, and is that part of the reason why you're asking?
It's the very reason on Porter. Yes, ma'am.
Yeah.
We're giving up the required setbacks 15 feet off of the existing right-of-way, and Metro's asking us to dedicate 14 feet, which is bringing where we were. If there were no right-of-way dedications, the only setback special exception we'd have would be on Riverside.
Okay.
In that width. So, but that's the thing. I hope will bring some assurance that this situation. I can't help on number 7. That's across the street, but at least on this particular property, I've witnessed this myself, and this is going to go away because. And one of the reasons we are going to curb it. We are going to do as Mr. Taylor talked about the Cadillac sidewalks, which we'll argue whether 8 feet's too wide for another day, but. The goal of this, we had looked at doing on-street parking to count toward our requirement. Public Works said no. So even the city wants this to go away. So that's one of the things we'll be accomplishing in this. So just to cover her,
You did meet all the parking requirements. You're not
we do.
for parking
We're actually
variance.
+3 on parking.
And there's only one curb cut on Riverside to enter and exit the property?
Correct. And it really doesn't affect this board, or there may be some shift in the location of that, so our unit one of the units might flip to the other side of the ramp. The idea to try to line those 2 ramps up across so that folks don't sort of cheat across Riverside and go the wrong way. But that's something we'll handle in permitting. I think Public Works mentioned.
And how many parking spaces are you going to have?
We're going to have 20 spaces total on the property, including the rear-loaded garages, and 17 is required under the zoning code. I would disagree with the assessment in this statement that it's in contravention of 17030, that to promote pedestrian friendly, it's always been since the adoption of the UZO in around 2000. The original UZO required your setbacks to be 0, and the council actually amended it to push it back. But you used to have no choice. We'd had folks come to this board asking to scoot back, which seems counterintuitive. But to promote a pedestrian friendly is to bring that setback closer to the street, and to install the sidewalks, to have that interaction at the street is the direct reasoning for the urban zoning overlay originally, and then the setback special exceptions that came later. The setback special exception came as a result of the original requirement that you had to be at 0. You didn't have a choice. So, but that's hopefully that addresses our concerns. I really don't have anything else to add.
Any other questions? Questions? All right. Thank you.
y'all.
We'll close the public hearing. Thoughts?
Well,
Go ahead.
I think it seems like a very appropriate request for a special exception.
I agree.
Motion?
You wanna make a motion?
Sure, I will move to grant the special exception request for the street setbacks.
Second.
Have a motion, have a second. Any discussion? All in favor, say aye. Any opposed? That passes. Good luck. Thank you. Next case.
She did a good job.
Next case, 2019-375, involving property at 114 and 114B Lindsley Park Drive. This is a request for a variance from sidewalk requirements to construct 2 single-family homes without building sidewalks or paying into the fund. Before you is a zoning map showing the zoning of the property as R6. Aerial photography showing you the parcel and surrounding areas. This is the site plan submitted by the applicant, and finally the photograph showing you the current conditions of the property. Is there anyone here in opposition to case 375? Seeing none, the appellant will have 5 minutes to make your desired presentation. Please be sure to identify yourself by name and address.
My name is Michael Sobey. I now reside at 6626 Valley Drive, Brentwood, Tennessee. Forgive me, I thought I had 5 cases before me, so I have something in my mouth. I'm hoping this could be a very quick discussion. I can save a few minutes for any questions or rebuttals if it's necessary. Basically, we're asking for a variance from the requirement to build sidewalks on the front and back side of our property. We've had many discussions with our councilman, Brett Withers. I believe we came to an agreement, and he emailed you. And if you are agreeing with his recommendation, there's not much more I have to say. If you're looking for a hardship, I mean, just to kind of tweak the idea of a hardship, to be treated differently than everyone else on the block and all our other neighbors is kind of a hardship in itself, to be unjustly singled out and given different treatment from neighbors, which is why, we spoke to our councilman, and he agrees with our proposal.
So I guess the way I didn't see the site plan. I didn't understand the site plan when I saw it. The planning department basically said that you should pay for both sides, but normally on a corner lot, it's not uncommon for planning to just say one side or the other.
Right.
But the strangeness of your situation is that you face 2 separate streets, right?
Correct.
I mean, you're one parcel that fronts 2 streets. You're building 2 houses. It may appear that they're separate, but they're really the same, and so. So
Right.
You're saying, hey, I'm a corner lot, and Councilman Withers has said his
Well,
recommendation.
no, we're not a corner lot.
The what?
We're not a corner
No, you're not a
lot.
corner
Right.
lot, but it's behaving like, you have 2 streets on
Right.
one parcel, even though it's not a corner. And Councilman Withers has said that he recommends that you just pay on the Lindsley Park
Right,
side.
and we agree with that.
Be excused from the other is something that's different. So that kind of summarizes it. Is it
Right.
make sure I understand it right.
Right, exactly.
Okay.
And just to add a little bit more, on the backside, on I think 14th Street, there are other houses that front that, and in the past, the recent past, they've also been granted waivers from having to build sidewalks there. So that's kind of the hardship and the unjustness if, for some reason, we would now have to build sidewalks on both places where, our neighbors didn't. Not to mention the purposelessness of actually having a sidewalk that goes to nowhere, because the other houses that are new got a variance. So for decades, there'll be no building there. There'll be no sidewalk. It'll be connected to nothing. And like I said, these are discussions we had with Mr. Withers at length. And, so he agreed. And, like I said, I can go into all of these arguments again if it's necessary. Or if you just kind of understand that he's the councilman, we've talked about it, and you don't have any opposition, I can answer any other questions.
What's your total frontage between Lindsley, and it looks like the frontage is the same on Lindsley Park it is on South Street based on the shape of the lot. What is the total frontage there?
The total frontage?
Total frontage on both. Is it 50 feet? It looks like it may be 50 feet on each.
That sounds about right. I mean, it's about the same front and back.
So it would be a total of 100 feet?
Correct.
Okay.
That sounds right.
Okay.
Mr. Pepper, it looks like it's 50 on one side and 55 on the other, so the Lindsley Park Drive is 55 feet.
50 and 55?
That's what it looks like from our parcel viewer map.
And this is undeveloped, an undeveloped lot at this?
It's being developed now.
It's being developed. And you're going to put 2 houses, there'll be houses on each lot?
Yes. In fact, one of the applicants is going to be living in one, and I was actually going to be living in the other till my daughter now moved to Curry Ingram, way on the other side of town. So now we've got to be selling that and not moving there.
Any other comments?
I'm just having that mental difficulty in either pays into the fund or he goes to side.
Well, is that is that a question or discussion?
I'm just looking at it and going through it. He doesn't want to pay
But-
the fund, nor does he want to have a sidewalk. I understand his argument on the sidewalk.
Well, but that's, right. No, he hasn't objected to that. He said he'd like to pay on Lindsley, which is what Brett Withers suggested. And basically, the argument is it's behaving like a corner lot, even though it's not. And that's the argument. So,
And Chairman Taylor, you pointed out, isn't this about to change aren't the sidewalks? And
the sidewalk rule is getting ready to change, but I don't know how that impacts it. But I guess, let me ask you, does anybody have another question for the applicant? Then I'm going to close the public hearing and then okay.
I was just asking because I think in previous meetings you've given applicants opportunity to defer because they may get more.
Well,
you know where I'm on these. I mean, this is Metro Council unanimously, as I understand it, said you have to contribute, and they didn't put any limits on the sizes. And I have consistently, even with people that with more than 100 feet of frontage, have taken the position they've got to either build or contribute. And so, I'm prefacing by saying you've given people the opportunity in the past to wait and see if the law is more favorable. I don't know if that's.
As I understand it from our recent kind of training session, was that the law allows the planning department, the zoning administrator, to kind of negotiate a solution, and if the applicant and the other two parties agree, then they don't have to come to us, and if they don't agree, they come to us. And this is a case where planning has recommended that they pay on both sides, and the applicant is saying, no, I really should pay on one, and the council member, in this case, who I don't believe has a say in the new law, but certainly, is usually consulted when we deal these, agrees with the applicant. And he is a council member that has been extraordinarily pro-sidewalk, and it's rare for him to say, here's an exception to the rule. But I do think in that district, he has been consistent on corner lots, and I think this one behaves like a corner lot. And it's fair enough to have a difference of opinion, but I tend to view it that way, to say, that this is unique, and that it's two frontages, and it's not uncommon for us to grant it, but we certainly don't have to.
I wanted, maybe we have to reopen the public hearing, because I understand what you're saying. I'm wondering if the applicant would be fine with paying on one side and dedicating the other side. I get he has double frontage, so, at some point it might not even be developed. We don't know what will happen in the future, but that was one of my questions.
So I will open the public hearing. The question is, would you be amenable to, you've already said you'd be willing to pay the in lieu fee on Lindsley, according to your conversation. Would you also be willing to dedicate the right-of-way for a sidewalk on 15th Street and not pay or build on 15th Street?
When you say dedicated but not pay
that
it,
means that if the city chooses to build a sidewalk there, then they can come in and build
if the
a sidewalk.
city chooses to build it and it's no cost to us, I think we'd be in agreement.
Okay, yeah.
But just for informational purposes, I'm certainly fine with that. But again, it would make no sense because all the other houses on the block don't have the sidewalks.
Well, and they may not, and it may not, and again, you can assess the odds. You know your street, but that's not an uncommon request from this board.
But we're not against that.
Okay. So
I would support it.
I'll close the public hearing again. Is that a motion?
That is a motion. A motion that the applicant is granted a variance on the conditions that he pays the in lieu of fee on the Lindsley Park Drive side and dedicate the right-of-way for a sidewalk if it so happens in the future on 15th.
Second. Got a motion, have a second. Any discussion? All in favor say aye. Any opposed? That passes 5-1. Next case.
Thank you.
At 324 Rose Street. This is a request for a variance from front, side, and rear setbacks in order to construct a single-family home. Before you is the zoning map showing you the zoning of the property is RS5. Aerial photography giving you a sense of the surrounding area. This is the site plan submitted by the applicant. And finally, the current conditions of the property as well as up and down the street. Is there anyone here in opposition to case 377? Seeing none, the appellant will have 5 minutes to make your desired presentation. Please be sure to state your name and address.
I'm Jonathan Bunton, 5105 Cochran Drive, Nashville, Tennessee, 37220. And can you go back to the RS5 map? Only one parcel is highlighted, but it's going to be the two parcels there.
Right.
I'm going to combine them. So most of the time people come to you guys, right, want to put two homes on one lot. I want to put one house on two lots. Right.
And what a
And why do you want to do that?
strange little lot you have.
I would like to put two there, but we'll get to that in a second. We'll get to that in a second. So for the front setback, I think there's contextual arguments to be made. The 320 Rose Street, which is the third lot to the right, as you can see, that structure sits on the lot line, right? So there's no front setback there. And then 318 Rose Street, which is the one right next to it, is about 20 feet back. Again, both within that 27-foot front setback that is required.
How far is that from the street?
Which one?
Either. I mean, you say you want 10 feet, but how far is that actually from the street? Because it looks like the property line and the street are.
I do not know the distance from the street. I know the property line is off the street,
Yeah.
but I don't know how far the property line is off the street. 321 Rose Street, 317 Rose Street, and 315 Rose Street also seem to have front setbacks less than 21 feet, and I pulled on like the CRS measurement tool, kind of their front setbacks. As far as a hardship argument goes, it does back up to 440, creating, obviously, the original lots were bigger and would allow for me to make front setbacks and rear setbacks and also side setbacks. I would build two homes, obviously, if I could, but yeah, there's that. Again, this 3-foot side setback, I'm not really sure. My proposed site plan has 25 feet on the west side and 20 on the east side. I'm not really sure what this 3-foot side setback is, but contextually.
Is it a build two? Is it a build two on the side?
Because this is an undersized lot, it would be illegally undersized lots if it's under 37 or under 5,000 square feet.
Yeah.
Rather, it's a build two of 3 feet instead of a setback of 5.
Okay.
So you're wanting to build further away from the side than their code requires you to build, which is probably a.
Yes.
Yeah. Okay.
So the idea being that the home would have a yard of some sort and then parking on the other side.
So you want a shorter setback in the front and the back that code requires, and a bigger setback on the side.
Yes.
Just so.
Yes.
Trying to center it.
Creating something that's viable.
Yeah, right.
Creating something that's viable. And then for the rear setback, again, the context, 320 Rose Street and 318 Rose Street, their rear setbacks are also less than 20 feet. And then 316, again, on the CRS tax measurement tool, I measured it as just under. I don't know. It's not a survey. I understand that's not perfect. As far as the overall lot being under 5,000 square feet, there's also context for that, with 320, 318, and 316 Rose Street all being under 5,000 square feet. Combining these two lots would create a lot larger than that of 320 and 318 Rose Street. So there's that. When combined, the lot would be over that 3,750 square foot minimum per code. I believe there is some precedence in the interstate being hardship with case 2019-230 with James Crockett, where he had a lot that backed up to the interstate, and the board unanimously voted that was legitimate hardship and treated it as if the interstate was not there. That is all I have. And I have this here, if you guys want a copy of this map. I only brought 5.
It's in our packet. I think we
Okay.
yeah, we I think most of us, a lot of us are looking at that right now. Any questions?
So when they're combined, you do meet the minimum lot area. That's
Yes,
why
sir.
you're combining them.
3,850 square feet. It's over the minimum.
Okay.
I think the minimum's 3,750.
Yes.
Something, it's showing up here on my,
The survey
one
showed.
form is being, it says, located in RS5 zoning district, 5,000 square foot minimum lot area. That's why I was just trying to clarify that. So you don't need
I saw that too.
you just need variances for the front, the side, and the rear, correct? That's all the variances you need.
It's on the application, Ms. Lamb. It does say at the bottom that in the RS5, it's a 5,000 square foot minimum lot area, and this combined parcel is 3,876.
So if it's RS5, then 5,000 would be the base requirement, but if it's a legally non-conforming lot, you can go down to 3,750. But if you're under 5,000, if you're legally non-conforming lot under 5,000, that's where you get the build to.
He doesn't need a separate variance to build under the 5,000 then? Because I
thought that's what he was.
No,
I thought that was part of this application. Yeah, he would need to. He would need to be granted a variance to build on a lot under 3,750.
But it's not 3,750.
It's not.
It's in excess of 3,750.
Oh, then he would not
once
need that
combines
variance.
them.
Then if he combines them, he would not need that variance because
Okay.
if the combination would be greater than 3,750.
Okay. Does that
Everybody
go?
good?
Does
Yes,
that
that
go where
does,
you're
yeah.
going?
Thank you. I understand it now.
All right. Any other
It is.
Any other questions? Anything else to add?
No, sir.
We're closed to public hearing. Who would ever thought that house would go on that lot?
Oh, we've seen one.
It's Nashville. I know it's Nashville. Well, and it's true. It's
And the interstate did create
Yeah.
a lot of that.
a little bit of a different interstate with different historical issues for the interstate, but it's the same principal concept. And to me, on these situations, the build to the side setback is not, to me, it's a no-brainer. It's you're building further away, which is more consistent with what the houses are. The front setback is not too much of a, really neither of the setbacks are because of the right-of-way with the interstate, and then the road clearly is, the house next to where it's under the word street is the one that actually is on or over the property line at the front, and there's still a pretty good little ways to the street, and it's on a dead-end street, so I don't really...
I did not have an issue with the requested variances.
I think also with the front, because it is a classic case of the interstate coming through and making the lot uncharacteristic, and you don't have as much room to build towards the back, so you need that front setback, not just because of the way the interstate chopped all this up.
I think so too.
The lot has to contain a minimum of 3,700 square feet and have to have existed prior to the effective date of this ordinance. So if he's going to combine the lots now to create that lot, that obviously would be after this ordinance that allows you to build on 3,750. So he can combine the lots, but he would be required to meet the 5,000 square foot. So if combining the lots provides him 5,000 square feet, he'd be fine.
It says that it doesn't.
It says what?
What I'm looking at,
So if it doesn't provide 5,000 square feet, then what? He has to come back for another variance?
Yes, he'd have to come back for another variance.
Okay, so we can approve the 3 variances today.
And that would be a lot size variance to build on a lot that's under the minimum 3,750.
But
it's not under 3,750 once they're combined.
I'm sorry, then under the 5,000. Yes, I'm sorry.
Okay.
Is that not in? Oh, sorry, that's all.
Well, I don't know that any of that is. I mean, wasn't noticed, and that wasn't what was
Correct.
applied for.
Correct.
So
I
you
had
may,
misspoken when I
basically, the bottom
answered.
line is, you may have an issue you got to deal with codes, and you may have to come back, but the 3 variances that were noticed and applied for right now are really independent of that question.
Y'all can make an order one way or the other on the variances, and then when he comes in, with his site plan, then we may have other issues we need to deal with.
Okay.
Well, he put on the application non-conforming lot area, so.
And that's what I'm saying. That's why what I just was answering about the non-conforming lot. I don't think that this would meet that provision of the code to be a legally non-conforming lot, because that provision of the code says if you were contain the minimum 3750 and existed prior to the effective date of the ordinance. So he's not legally non-conforming because if he's
Okay.
Because he's creating it after the ordinance.
now the tiny little, the 2 individual parcels would be, but if he wants to combine them and rely on that, that wouldn't be legally non-conforming.
So he could make the case for each of those 2 little ones, but the one big one, he's going to have to come back for a variance, which seems to make sense because let's address the 3 variances that are being requested, which I haven't heard opposition to.
If we condition granting the lot would it, maybe I should be aiming my question over this direction. If we condition the variance on the lots had to be combined, I think they're already combined.
They're 2 separate buildings that you had.
But had him where it was conditioned on combining it, he's still not allowed to build. He can't build.
But as soon as he creates the lot, it will be 3,800 and something square feet. It's under 5,000 square feet, and so he's still got to come back. So
I'm trying to miss that extra step.
yeah, but that's something he can deal with at codes. But I'll move that we approve the variance, the front, the side, and the rear setback as requested, based on the odd shape of the lot and the interstate going through the property. Got a motion? Got a second? Any other discussion? All in favor, say aye. Aye. Any opposed? Okay. Your variance is passed. You go back to codes and figure out if you need to come back for a lot size variance.
Thank you so much.
Sure thing. Good luck. Next case.
2019-386, involving property at 1811 28th Avenue North. This is a variance request from the front setback requirements in order to construct a single-family home. Before you is a zoning map showing the zoning of the property is RS5. Aerial photography showing you the property and the surrounding area. This is the site plan submitted by the applicant before you now, and finally the current conditions of the property from the recent site visit. Is there anyone here in opposition to case 386? So there is opposition. Each side will have 10 minutes. Please make sure to identify yourself by name and address.
Good afternoon. My name's Eric Johnson. I'm at 314 33rd Avenue North in Nashville, 37209. And we bought this property years ago at 1811 28th Avenue North, and when we went to, it's a large piece of property, and it's a little over 1/3 of an acre. So we thought we would see if the possibility of subdividing it. So when we were subdividing it through the surveys, we realized that there was a sewer easement that ran across Ed Temple through that property and went to a manhole on 28th Avenue side, where that camera is, I believe. So through the subdivision of it, the sewer easement has created really a challenge to find a building envelope for the northern half of the lot. I don't know if y'all have the survey of it, but with but after planning approved the subdivision of the lots and us knowing where that sewer easement was, we thought, well, we still have some room to perhaps build a smaller home. So we went to zoning, and that's when they said, well, you'd have to be compliant with houses that are running with Ed Temple Boulevard. And those homes, which you can see those townhomes looking style homes on the right-hand side, they were sitting off the road almost 50 feet. And those are really unique. As you can see, they all those townhomes that go from my lot all the way north, they were all built by the same developer, and they all have access through a drive, a shared drive that brings them all to the rear of their homes. And my thought is that when they constructed this, they were, as they probably should have been, trying to be compliant with trying to stay consistent on that front setback of the 28th Avenue. Those ones that we can see from this photo here, they're about 50 feet off of Ed Temple. However, Ed Temple has no access to those properties. But further up, they have another phase of those that I don't think we can see on that shot there. However, there's quite a few more of those homes further towards Clarksville Highway that, again, they shared a driveway to get them access into both sides of the property, and those houses are much closer to Ed Temple Boulevard. Again, I really don't think they were considering much about setbacks on the Ed Temple as much as they were about access to the rear of all the properties and keeping the 28th Avenue compliant. So I guess my hardship is now that they've approved my subdivision of this large lot, if I have to set, and when I say my front setback, the Ed Temple side front setback, if I've got to go back all the way almost 50 feet, it forces me into that sewer easement, and I don't have a building envelope.
It's 40 feet, isn't it 40 feet?
Whatever.
Setback requirement, 40 feet.
They said something about I got to be like the 4 houses to the side of me or whatever.
The contextual street setback, and it was 40 feet is what the average is.
Okay, but 40 feet is required, what's required. Okay.
So, and at 20 feet, and my hopes is to perhaps get a variance for a 20-foot setback, and that would still give me a building envelope of, I could build about an 841 square foot, one level, one story envelope with a 20-foot setback. To lose 20 more feet, I don't know, it'd probably be a 200 square foot house off on that corner there.
Yeah, I guess I'm having a tough time seeing how you have a building envelope at all on the one on Ed Temple. Because it looks like that sewer easement runs right through the middle of that parcel. And the one that faces 28th, I'm not sure I see why you can't go back 40 feet.
Yeah, I've got no problem with the one on 28. That lot's got plenty of envelope.
Right.
No, I'm.
But I guess I don't even see.
If you don't mind, I'll hand you this.
Well, I think that's what you. Yeah, you can show me what you.
Got this building envelope.
Yeah, I think we've seen that.
Yeah, I don't see either, based on where this sewer easement is, how you even go back 20 feet and have, I mean, it looks like the sewer easement bisects the lot.
I know, but it really, in that page that the young lady has, it shows that it's kind of going from that, I guess that would be, if that's north and this is south, that southern corner, it kind of crosses the lot.
I have a question for codes. If this lot's already been subdivided, does it not have two addresses? So it would have an Ed Temple address and a.
It's split between the two, they would face out to go each way, it sounds like, if they were subdivided. I don't have the document yet.
Because he said that it's subdivided, but the application is only.
It's been approved, and those houses that are on the left, they are Ed Temple addresses, and then the ones on the right are 28th Avenue.
But has it already been subdivided?
It's been approved. We hadn't recorded it yet. When I went to zoning to try to find my building footprint, then.
When did
Because
you?
I guess the question is if it's what address are. If it's been subdivided, then don't we have two properties and we should have two cases, or? And.
Mr. Chairman, it sounds like the question is the difference between having had an approval of a subdivision and the actual recording of the subdivision, which would ultimately yield the two addresses, just like you've referenced. And yes, it would be appropriate, if I understand Mr. Johnson's appeal, to grant a setback variance, if that is in fact the board's inclination, on the Ed Temple side, which would eventually be an Ed Temple address, but because the approved subdivision has not yet taken place or been filed or recorded, as will eventually be the case, doubtless, you don't have an Ed Temple address, hence the address that shows on all of our notices and on the docket for today's discussion. It sounds like, if I've understood the appeal correctly, it's just on the Ed Temple frontage, meaning the soon-to-be-created subdivided lot, where they will need that setback variance. It sounds like you're okay on the 28th Avenue side, if I understand correctly. The address that we have in front of us today is 28th Avenue address because the other one hasn't been created yet.
Okay. When did you buy this lot? I understand you're going to subdivide it, but it was one lot when you bought it. When did you buy it?
It was probably 2009.
And was the sewer easement? I mean, what?
I don't know. I bought it in an auction. But yeah, there's a property right across the street at that driveway. You see that sits.
Well, the easement you weren't given. The property wasn't condemned after you bought it for the easement. Is that fair to say? It did.
I was not aware that it was condemned.
Okay, so then it would have been there when you bought it at auction.
The sewer easement. The
sewer easement.
I believe it was there before 2009. Yes, sir.
Are you trying to get it at self-imposed?
Yeah, I mean, I think if you it's pretty clear looking at the part of this lot that faces at Temple that the sewer easement runs right. I'm surprised any of that lot's buildable.
Did you look at that?
Yeah, I did, and I can't tell much more.
Did you see where the building footprint was?
I did kind of see it, but
yes,
that is what I'm getting at. Is I think it's
any other questions for the applicant at this point? Do you have anything to add? If not, we'll go to the opposition, and then you'll have 5 minutes for rebuttal.
Okay.
5 minutes, 32 seconds for rebuttal, and we'll hear from the opposition. All right. Can you state your name?
Good afternoon. My name is Melvin Gill, 1821 Ed Temple Boulevard. And to give you a little history, that sewer line that crosses the subject property has been there probably since the late 50s or 60s. It was, you might say, an illegal sewer line. I developed property that's directly across the street. There was no water or sewer on the west side of Ed Temple. There was no water or sewer, so the city extended a water line from the fire hydrant at the golf course clubhouse to my property. And they repaired the sewer line that was on the property that's adjacent, that was the old El Dorado Motel property. So what they did was the city took over that sewer line from the west side of Ed Temple all the way over to 28th Avenue North. And that's what happened there. So it's been there. It was there when he purchased the property, and that's what the issue is now. As a single lot, it's buildable. The problem is that he wants to disturb or not keep in line with or in compliance with the established development pattern of the area. The houses that front Ed Temple Boulevard are set back 47 feet. The ones that front 28th Avenue North are set back 34 feet. What he's proposing is to have a setback that would allow him to extend 27 feet in front of the houses that are facing Ed Temple Boulevard. Now, what has actually happened is the sewer line has created what is considered perhaps an irregular shaped lot. But because that sewer line can be relocated so that he can have a rectangular shaped lot, he has an option. He actually created the hardship that he's claiming himself by subdividing the property. He has an approved subdivision now for that property that divides that property in half, 99 feet from the 28th Avenue side. It's 94 feet deep from the Ed Temple Boulevard side. If that sewer line is relocated so that it runs along the edge, the southern edge of the property, then he would have buildable space. So to me, I submitted prior to the date of.
We have your letter.
Okay.
Yes, sir.
And you have those photos that I.
Yes, sir.
Doctored or whatever. I might have been a little overzealous in how I placed
They
that
were
information.
about as thorough as anybody submitted. I was very impressed.
So I was showing the setbacks. I actually didn't show the sewer line because you have a site plan showing the sewer line. Right. But if I believe he should comply. My councilman unfortunately couldn't be here. And what I would like to leave with you too are some signatures that I got from neighboring property owners when this is over with. But my councilman is opposed to it too because he would like to stay with the established development pattern of that particular block, which if granted it wouldn't be. And in addition, any resident or property owner of the property for a house that's 20 feet from Ed Temple Boulevard, in my opinion, would create an adverse impact psychologically, physically for the property because of the high volume traffic, the noise and dust. And I think that's something also that should be considered. I just don't think a house should be that close to a major street. It's required to be 40 feet back, but because the houses that are there are 47 feet back, he should be set back the same distance from Ed Temple as the nearest 4 houses to his property. And he's asking to be put forward on that.
And Mr. Gill, you can go ahead. If you want to hand out your survey.
I don't have. No, I just had one. I didn't realize that I shouldn't say I didn't realize. I just didn't get a copy of these signatures. I just want to leave that with you as a record. I don't know that it'll matter necessarily, but I was still making comments because what the owner is doing is he's wanting to maximize the development potential of the property, and by doing so, he created that unusual circumstance itself. The sewer line should not dictate the shape of a property since it can be moved, and I'm opposed to that.
Okay. Mr. Gill.
And also, I would like. I'm sorry. Go ahead.
I'm sorry. I had a question. Can you tell me about if we keep coming down where the subject property is with the red dot? coming down this side, what happens? What is the neighborhood that we can't see?
What's happening
Is that
there is
buildable
that's
property?
That's church property.
Okay.
That's church property from the
Next door to
southern
the
edge of his
applicant
property all
is
the way
church.
to Buchanan Street.
Okay,
Between Ed Temple and 28 belongs to Howard Congregational Church.
okay. Okay. Thank you.
Any questions, Mr. Gill? Mr. Gill,
Well,
can I-
and I just wanted to point out the fact that when you're developing property like that, it's no different than buying a piece of property with a house on it and you demolish it. That's part of the construction cost. You're doing that to get the maximum development potential. You should be able to relocate the sewer line, and that's, to me, that's that simple. It's a cost, but I don't know that the board is in a position to subsidize the development cost of a property owner.
All right.
And I have this, what I give it to.
You can just give it to me, and I'll, or give it, actually go give it to Mr. Poole and. All right, thank you. We'll hear back from the applicant. And I'm not sure how many minutes you have, but I thought it was 5 and some.
Well, I understand his point. Actually, really, it's an RS5 zoning area, and, I've got almost 15,000 square feet. So I've always thought when I purchased it that this thing perhaps could be subdivided. It's my thought this would be an excellent place for me to build a home eventually, and when I do, it's going to be a one-story. I'm at that age, so really the sewer easement did throw me off a little bit as far as the footprint. Mr. Gill was correct. All that property that's close to Ed Temple, that's all, I think it's Howard Church or something, but a well-established church that's been there forever. But if you guys would look just underneath the address of 1811, the lot that's next to my 28th Avenue portion is an NES power station. And so for me, the buildable area as it sits now, perhaps without the extreme expense of moving that lot is like, I don't know, it's almost 200 feet or something.
But isn't that in part why the lot was so big? I mean, the unusual size of your lot was in part because there was a 60-year-old sewer there. I mean, it's not, I guess I'm just really trying to struggle with the question of, how did you not create this situation? Why is this not self-imposed? Because you have a very buildable lot on the 28th Avenue side without needing any setbacks, and the Temple side is probably not buildable because of the sewer going down the middle of it. And by choosing to subdivide it, you've created a hardship on the Temple side that.
And it's through subdividing it that I discovered the sewer easement.
Right.
So it's not like I knew about that. So then once I realized my building envelope had gotten smaller, and then I realized what the setbacks zoning preliminary inquiry told me that, hey, you got to be compliant with the houses to the right of you. That's when I realized that maybe I had a possible argument, because I do believe, again, in my heart of hearts, that development that's to the right of me, sir, that has private access through a drive is not a typical neighborhood as to the other side of 28th Avenue, where everybody has their own driveways, everybody has their own front elevation.
Are any of those 20 feet from the road?
I believe some of those are across the street.
If I may.
And I'll end it with because of those drives pulling in, they had no consideration for that setback off that street at that time. Now, they may have rules and they may have 40-foot setbacks these days, but if you go up further towards Clarksville Highway in that other phase that same developer built all those homes, they're not 47 feet off Ed Temple Boulevard.
Okay. Any questions? Anything else to add?
Thanks, Scott.
All right, great. We will close the public hearing. Thank you. Thoughts?
I can't really get there on this one.
Yeah, I don't see. I think it feels self-imposed.
Yeah, there's no question.
Yeah, I agree.
Yeah, I agree.
Motion.
Motion
Is there a motion to deny the variance? Is there a second? Motion to deny the variance. There's a second. Any other discussion? All in favor to deny the variance, raise your hand. Variance is denied. Thank you. Next case.
Moving on now to our short-term rental docket.
Page 13.
We're getting there. First case on the short-term rental docket is case 2019-118 involving property at 626 Huntington Parkway, challenging the denial of a permit due to operation prior to obtaining a permit. Is there anyone here? Is the appellant here for 118? 626 Huntington Parkway, Cody Lefevre.
Is the appellant here? I'll move that we defer this one meeting. And we haven't deferred this.
I don't think so. That's an old number, which makes me wonder, but I don't think that we have.
All right. Well, I'll move that we defer this at least one meeting.
Second.
Just one more meeting. Second. Any opposition? Any discussion? All in favor,
Thank
say
you.
aye.
Aye.
All right. That one's deferred to next time.
Case 2019-347 involving property at 582 Whispering Hills Drive. Another challenge to the denial of a permit for operating without the permit. Is there anyone here in opposition to case 347? All right. Before the appellant makes your presentation, you'll have 5 minutes for your presentation. Before you make your presentations, Mac McBroom is here and will make the presentation on behalf of staff, and then you'll have an opportunity to respond.
Good afternoon, Board. The case is advertising, operating short-term rental without a permit. Okay. The first online activity occurred on March the 8th, 2019. April of 2019, the first documented stay. May the 30th of 2019, the host cease and desist letter was sent. Estimated delivery on June the 7th. The advertisement was removed on or about June the 15th of 2019. One documented stay that month, June 2019. BZA appeal was filed on June the 20th, and there are no documented stays, and the ad was not reposted after the BZA appeal was filed, and there were no documented complaints on this property.
All right. If you would state your name, address, and tell us why you're here.
Good afternoon. My name is Peter Nielsen.
And I'm Sarah Nielsen.
We live at 582 Whispering Hills Drive, Nashville, Tennessee, 37211. Thank you for your time today and hearing our case. My wife and I have lived in Nashville for less than 2 years now. We purchased this home about a year ago with the intention of renting it out via Airbnb to help pay the mortgage and begin a family. We were admittedly ignorant to the process as it relates to city rules, ordinances, regulations, and law, and did not realize that we were required to obtain a short-term rental permit after signing up with Airbnb. We incorrectly assumed that we were in accordance with any laws through the process of signing up with Airbnb. We began renting our property in May 2019. While we rented, we did not receive a single complaint from our neighbors. We also live in the property and were present when guests stayed in our rental. It wasn't until we received this letter at the end of May that we realized that we were in violation of the city ordinance. The letter was dated at the end of May. However, my wife and I were on a 18-day trip abroad, and so we read the letter on June 14th. And after reading the letter, we immediately took down the listing, worked with Airbnb to immediately cancel all future reservations, and promptly remitted all occupancy taxes. We then pursued obtaining a permit. We gathered all the required documentation, signatures from our neighbors, etc. But while filing for the permit, a zoning officer informed us that we were required to appeal as we had been suspended.
What was the last day you rented the property?
I cannot provide you the exact day. I would assume that we rented it one time in June. That night that we returned, we had one rental, and I believe that after that, all future reservations were canceled. If my recollection serves me.
So it's the 15th, nobody after the 15th?
Correct.
Correct.
Okay. Any questions? Anything else to add?
Nope, other than we reached out to our councilman, Bob Nash. He's aware of our situation. He's communicated his appreciation of our desire to be compliant. He's aware.
All right. One documented stay, two documented stays. Did everything apparently right after, at least we don't have evidence that they didn't do anything right after the 15th of June.
It's getting a little late in the period that people don't know about short-term rentals, though, don't you think?
May I speak to that?
I know the public hearing's closed, ma'am, sorry. You know, if you don't know, you don't know. I mean, it may be so. I mean, but, I mean, you know, ask all of our neighbors who our council lady is, and maybe 80% would know, maybe more. Go to other spots and ask, who their council person is. I just don't know. I don't know. I don't know. I think because frankly, why would you go through this if you knew? I mean,
Right.
if you knew you had to get a permit,
Right.
and you knew you had to sit through a 4-hour meeting, if you didn't,
Right.
why would you do that? So that to me
Noted.
is kind of the evidence. I mean,
Are you saying our meetings are boring and not worth attending just to be here?
well, one of these days we're going to see somebody in the audience that's like just doing this for punishment, coming to watch us. And I'm always shocked at who tells me they watch us on Channel 3. But, so I don't know. I mean,
I interrupted you. Go
no,
ahead.
well,
I'm good.
sometimes you got to interrupt me to actually speak. 'Cause I think, I don't know. I was thinking 4 months is what we normally do on this. Really, you do everything right, and that would put them at the 15th of October. I mean, I'll move the zoning administrator didn't err, and they can apply for a permit on the 15th of October. October 10/15.
I'll second.
Got a motion, got a second. Any discussion? That's the sign that says.
No, I mean, I just think that, this is a small business, and that there's always rules when you run a small business. And I understand that people don't know, but, if you have an LLC and you don't know all the rules and you get dinged for those rules, that doesn't mean that those rules aren't real. So, I understand that you're putting the October date based off the June date, but that was it.
Well, and
To Cindy's point, but I mean,
yeah.
that was it.
Well, I'm sorry. Well, we'll see. And every case is a little different, and this one is to me the rare one that says, you really truly didn't rent much. You took it down when you found
That's
out.
true.
You hadn't done it since,
That's true.
and that's why. But and again, we have 4 more we can hash through to see where we evolve to the right answer. But we have a motion and a second, and any other discussion?
I'll say, I think that is a penalty. They did incur a penalty by not renting for however many days they haven't rented, and they won't be able to reapply.
True.
So they'll have to reapply and apply for the first time and go
Right.
through the process. So, I think they are assessed a penalty. I don't think we are letting them off scot-free. I think originally, it was a mandatory 1 year. That seemed really harsh because some of us forget to renew our driver's license. Not me, but I'm sure there are some people out there that forget.
Well, and some people do interpret the rule as a year, unless you work your way down. The wording of the rule is up to a year. For some of us, we look at it as 0 to 12. and maybe it's your perspective on how you view
The penalty.
which direction you're coming from on the penalty as to where you fall. But anyway, we have a motion and a second. If any other discussion, we'll vote on this. All in favor, raise your hand, say aye. Any opposed? One pass. Well, I had one opposed. You opposed.
Yeah.
So 5-1.
It wasn't you.
You can apply.
There were
for a
other
permit on,
people that opposed.
October
Wasn't Tom
15th.
this time.
Don't do anything until you get that permit.
Thank you.
Thank you.
Okay. Next case.
Mr. Chairman, case 118 that we just deferred as being a no-show, the building was locked and they were locked outside. So they're here now. It might be appropriate to go ahead and hear that case.
Okay.
This is 626 Huntington Parkway. Is there anyone here in opposition to case 118?
Sorry.
Seeing none, Mr. McBroom will make the presentation on behalf of staff, and then Mr. Bain, you'll have an opportunity to respond.
This is advertising and operating a short-term rental without a permit. 7/7 of 18 was the first online activity. July of 2018, one documented stay. August 2nd of 2018, the STRP application process was begun. August of 2018, there were 11 documented stays. September 17th of 2018, the use and occupancy life safety final inspection rejected, means they failed. September of 2018, 11 documented stays. October of 2018, 7 documented stays. November of 2018, 3 documented stays. 12/10 of 18, the host cease and desist letter was mailed. 12/22 of 18, the ads removed. February the 7th of 2019, the ads reposted. February of 2019 saw 7 documented stays. March of 2019 saw 1 documented stay. Follow-up inspection on April the 2nd found that they had continued to advertise and operate without obtaining a permit, and so a warrant was requested. The ad was removed on or about March 23rd of 2019. 8/28 of this year, first court setting. It was a continuation. September 11th is the next court setting. There were no documented complaints on the property. The concern with this property is the appeal was filed on February the 7th of this year, and 7 reviews posted thereafter. Part of the appeal process is signing a notice stating that continued operation will be pursued in environmental court, and this case is now before the environmental court.
And Mike, you know why was it said there was a one court date on 8/22? Why was that continued? Do you know?
No, sir, I do not know.
Okay. All right. State your name and tell us why you're here.
Cleveland Bain, West Nashville Law Group, 4800 Charlotte Avenue. Mr. Chairman, thank you for the time. I can answer your question about that continuance. I think there was a service of process issue about that citation because I accepted service from Mrs. Lamb here recently on that, and I think that's reset to 9/11. But just to clear that up. And if I may ask the inspector a question, he was saying or showing that there were advertisements and like stays after February of 2019. Did I hear those dates correctly?
Yes.
Yes.
Because my understanding is everything that I pulled from the board packets and what I had is, so we were retained earlier in the year. And I said, first of all, make sure that you take down any listings and any postings. Because I think if you heard the timeline there was some confusion, I think, on the part of my client of like when you were able to actually operate a short-term rental permit. He applied, and then he went through the first 2 stages, and then there was an issue about a window in a bedroom. This is obviously an owner-occupied short-term rental. And the fire marshal came out and said that it does not meet the egress. He came back. They had several dialogues between the fire marshal's office and himself, requested that someone else come out and look at the egress because he had consulted some sort of contractor or someone about correcting the window. They said, you're going to have to reapply. He went back in December after he got the letter. And he was notified by the codes department at that point in time, like, we can't give you a permit, you've been operating without a permit, you know, you're gonna have to wait a year or whatever. We filed an appeal. And then when I took over the case, I said, you know, take down the advertisements, don't list it anymore. And I was like, go some period of time with no advertisements, no bookings, and then we will go to the BZA and say, look, we've taken all the steps that we need to. We've got these ingress, egress issues situated, and just respectfully request that the board shorten that period of time. Now, I understand we're going to have to go see Metro Legal next week after this, but when we filed that appeal, we were not aware of like the pending citation. So there's a factual issue about these bookings. Everything that I have was that after we submitted on February 5th and my assistant signed the notice, we instructed no more notice, no more bookings. But I just heard the inspector say that he had confirmation of the bookings
I mean,
after
according
that
to our
time.
notes, or our summary of the case, it says that on February 7th, the ad was reposted, that there are 7 documented stays in February, 1 documented stay in March. In April, there was a follow-up by Mr. Osborne in the Codes Department, and that the ad was removed on or about March 23rd, and that there's no documented stays after March 23rd in our packet, but there were in February and March after the cease and desist letter was sent on the 10th of December.
Well, I would just ask my client, did you list or rent this? And
There was a like a disable feature, like you could just like suspend like the listing. And earlier this year, like whenever it was reposted, it was like it was booked. But then I called them and then told them what was going on, and then that my situation was the same, and you just cancel everything that was booked. But it was like a single room here and there, but
A single room here and there.
But nothing was booked. Whenever I told them that it was still supposed to be disabled, everything was canceled.
But I think a documented stay means that. Let me ask Mac, how do you
Well, that
determine a documented stay? Is that based on a review or?
Yes, it's determined by host compliance or tracking organization, and it is based upon reviews that are put on the property.
So if a review is, if I wrote a review on a property on Airbnb and said, hey, it was great, thanks for the stay, and I posted it in March, it may or may, I might have stayed at a different time, but it's assumed I stayed in March, or how do they know?
You have a 10-day window, I believe, in order to post your review, so they're very timely. And
So
also,
if I don't post my review,
after a certain period,
after
you're
10
not.
days, I can't post a
You can't
review.
post it.
All right.
And this is according to the Airbnb rules that you sign up, that no one reads whenever they agree to something. But it's all in there, and it also says that if you do not book through Airbnb, pay through Airbnb, then you're not allowed to post a review.
Okay. So how would there be 10 documented reviews, or it's 8 documented reviews in February and March if you didn't rent in some part of January, February, or March?
Right. That must have, me and my brother both owned the house, and I was out of the country for a while, so unless he did something, but I mean, I don't know.
So it's possible he did.
Is that a question?
Yeah, it's possible your brother did rent it. That's
I mean,
what could
if
happen.
it's on paper, then I mean, there's no way for me to refute that. But
And then, the other question that we get a lot on this is, is once there's a warrant and it goes to environmental court, there's a question we often struggle with of, who really has jurisdiction over this. And it sounds like you're due in environmental court next week, and so I guess we're here because it's on the docket, but it always is a little bit confusing to me to have knowing that that's coming up and then having us deal with this, but that may have been more a comment than a question.
That's the same situation. Like I said, we just received that warrant not too long ago. It's been pending for about 8 months because my understanding was that we were going to defer this. We actually deferred this indefinitely and renotice because we were going to make sure that there was enough time of no postings, no bookings for it not to be a waste of this board's time. And that's why when I pulled the board packets and was reviewing all this, I have the last listing as of February 7th, 2019, which was contemporaneously with the time that we filed the appeal and signed the notice that, you know, there can be no more bookings or listings. I don't know about this brother situation. I've never discussed this with him. That's correct.
All right. Is there any other questions? Is there anything else that you have to add? All right. We will close the public hearing. I guess the question for staff is, does any ruling on our part today impact the case in environmental court?
I think that this is like the other cases that have come before you in that situation, and Mr. Poole can correct me if he disagrees or if I misspeak, but you've got the issue before you today is whether we erred in denying the permit for operating either on an expired permit or without a permit. That's right. Before you. And if we erred, then y'all would make the determination that we erred. The separate issue is for a court to determine not whether we erred, but whether the applicant operated without a permit. So if you determine that we did not err, but you want to reduce the waiting period, or if you determine that if you determine...
It would still go to court.
It would still go to court, and whatever y'all do would run basically concurrently with whatever.
There was a time when an environmental court would kind of defer to us, and that would help settle
I'll
environmental
let Mr.
court.
Poole defer to that, to how the environmental court has been handling that. It's my understanding is that they're two separate issues, but he can weigh in on how the judge has handled those.
I don't know how it was prior to mine taking over, but we've all seen these two separate things.
Okay.
We're trying to determine two separate legal questions.
Okay. Yeah, and maybe it was maybe the way environmental court
so
handled things. 'Cause it seems like sometimes they've sent stuff to us, or
they have
deferred to us,
historically,
and if we settled it, then they would throw it out. And
they have in the sense that historically in straight, true zoning cases, in the sense that environmental court is a court of compliance, and the ultimate goal is to come into compliance. So if, for example, someone had a fence, that's a perfect example. Someone has a fence that's too tall and in violation of our zoning code, we might send an abate notice, take them to environmental court, and the environmental court might say, well, if y'all go to the board and the board gives you a variance to allow this, you would then be in compliance. These are a little different because they can't come into compliance by y'all saying that we didn't err. Does that make sense?
Mm-hmm. More questions? When does the 1-year wait period start?
From the date that the board finds that he operated without a permit.
Oh.
So that would be start from today.
Unless we state otherwise, right?
Unless you reduce it.
Okay.
If I might. We've got one lawyer and his client, and there are two names on here. Have we not got the service on? Or should I maybe looking to?
No, and I don't know. That would be the lawsuit, and we got service on as Mr. Bain said, he accepted service on the lawsuit. I'm not sure. Not having.
Yeah, his one particular client. I'm just curious. You're Cody, or you? Yeah. You don't know whether Austin, your brother, has gotten any information about this.
All right. Any other? All right. I can't remember if no questions. Have I closed the public hearing? It's getting late. Sorry, you all had nothing else to add, right? I asked that, so we'll close the public.
I would ask, my request out of all that was that if we could just go back to the December notice.
Like the board, I mean, it may be an act of futility, just depending on, what happens next week. But I've always found Metro Legal to be fair and nice and honest. reasonable, but I would just ask that we go back to the December date when we got the notice and filed the appeal, if instead of this, September date,
Even though
or maybe the last booking, which
sometime in March.
I guess is correct.
All right. Okay, I will close the public hearing. Tell us what you think.
Okay, the bothersome thing is that after the permit application was started back in August of 2018, there were still stays. So there were many stays after that time, and and I know that was before you were hired to help, but that part is bothersome to me.
Yeah, I mean, yeah. Other?
I was just counting the stays that we have, and I realize that might be an issue of fact because the appellant, he doesn't know whether or not those stays happen. So I think, I always rely on you, Mr. Chairman, to give me the range of, based off of previous cases, what this board typically does in situations like this.
I mean, it clearly is on the high side to me because of the, they went through the process. They knew that they had issues. They, even up to December are things that we've seen before, where people thought they had gotten through everything. And we've had folks that say, well, you have to do everything, but you got to put in a new smoke detector. Well, they put in the smoke detector and forgot to go back and get their permit. They did everything. Now, in this case, there wasn't really evidence that the window was actually fixed. And because I think that it sounds like that they were in the process of working on that. But once you get to December 10th and you had a letter that was sent and the ad was removed, which to me is a sign that you got the letter. Then it becomes, are you compliant or not? And there's just a lot of evidence that they weren't. And I don't know that it's the applicant that's here. He's talked about his brother being responsible as co-owner of the property, being responsible for it. But that also says that there's not a lot of coordination and not necessarily a lot of responsibility on who's in charge of this, And so to me, it's the kind of case that's on the higher side of the. I tend to divide them into thirds, and it clearly is on the high third, wherever the board would like to put that. And I'm open to whatever anybody would like to say on that.
I'm on the real high side. I mean, this is one of those times where his brother's not here, but he's here. He doesn't know what's going on.
Have a motion? So your motion is the zoning administrator did not err?
Exactly, he did not err.
And that the applicant's eligible to apply a year from today? That's your motion. Have a motion. Is there a second or more discussion?
I'll second the motion.
Have a motion, have a second. Any other discussion? Y'all?
I was going to say from March, but I think that we should hear from today. I don't know what you
Well, if
would
it doesn't pass it,
pertain
then we can have discussion on that. But
I was also going to go a year from March, but I'm inclined to, I can go either way.
well, it goes to environmental court, and environmental court is a stiffer penalty. Well, environmental court's a stiffer penalty, so I mean it's not. I don't know that either is going to do. I mean, I'm okay with March or some other time. I mean, it's.
I'll support the motion. There was a safety issue with the window that I haven't necessarily seen in all of the ones that I've dealt with, so I'll support Tom's motion.
All right, we have a motion. We have a second. All in favor, say aye. Any opposed? Motion passes. Good luck.
All right, thank you.
All right, next case.
Case 2019-355 involving property at 525 Rural Hill Road. That is a hard word to pronounce. Is there anyone here in opposition to case 355? Seeing none, Mr. McBroom will make the presentation on behalf of staff, and then the appellant will have 5 minutes to make your presentation.
The first online activity occurred on May the 8th of 2019. May of 2019, there were 3 documented stays. May 30th, the host cease and desist letter was sent and estimated to have arrived on June the 7th. Ad removed on or about June the 11th. BZ appeal was filed on June 25th. There were no other documented stays. The ad was not reposted, and there are no documented complaints.
All right, if you could state your name and address and tell us what happened.
Sure, thank you. My name is Reynolds Galden. It's my wife, Cassandra Galden. Live at 525 Rural Hill Road, Nashville, 37217. Yep, we're here because we violated the zoning law. We didn't know that we should have applied for a permit ahead of time. Our rental was a remodel in our home, and we took some bad advice with family saying that we should do Airbnb. That same family member, posted it online, and little did we know that we were doing it in error of a code violation. When we got the letter from code saying that we're in violation, we stopped what we were doing. We took immediate steps to start correcting that situation, and once we took those steps to correct the situation, we found out that there was going to be a waiting period on continuing to apply for the permit for the Airbnb. It's kind of discouraging because we really wanted to do it, but we were in violation. So we're here before the board. We humbly ask you to allow us to continue the permit process so we can do it right. And that's all I have to add as far as our neighbors. We've lived in our neighborhood 20 years. Nice, safe neighborhood. All of our neighbors support us being able to have a short-term rental in the neighborhood. And, our councilwoman, she knows about it. She didn't get any rejections from the letters that we sent out asking if anyone opposed our, us having an Airbnb. So that's why we're here. It's been a long day. I know you guys are tired. If I didn't know that this was the process we had to go through, we probably would have second-guessed it. But we do want to continue in the process. We just want to do it the right way. And we've learned that this is a serious process, and we definitely want to do what's right.
And so when you got the letter, you canceled any bookings, and you took it down, and you said,
Yeah.
"Oh no."
That was it. That was it.
All right.
We,
and it is your home. You live in the home.
Yes.
So it's an owner occupied.
Yes, and it's a one room
Okay.
that's in our home.
All right. Any questions?
I just wanted to know, did you guys know that one of your neighbors sent in a letter of opposition? She lives, it looks like, on Parkdale Drive.
No.
No, not at all.
Not at all.
And it says basically it's a great place to grow up, and it's not opposed. It's not saying that you all did anything. It's a generic. I don't like short-term rentals.
Yeah.
It disrupts the neighborhood.
Yeah.
And, but it's not addressing your specific short-term rental. But it does say that they would love to not have them in the neighborhood.
Well, Parkdale is a little further ways from our home, but all of the immediate neighbors right there within, say, 200 square feet, they all were supportive of us having an Airbnb there.
Okay. Any other questions? Anything you'd like to add?
It was just, we know that it's a year to reapply, but we was hoping that we can get that reduced based on us being dumb, trying to do this ahead of time.
Okay. All right, I'll close the public hearing.
Well, these are the cases where I think the 1-year penalty is too severe for just not knowing what to do. And I think people don't know a lot about the zoning code and what to do. And we've had people, and they didn't say it, but we've had people come before us and talk about, I thought I needed a business license. I didn't know I needed a permit. And so anyway, these are, and I've heard these cases ever since they started. So I know David and I have a lot of history with these cases. So if no one else has any other comments, let me just try a motion that the zoning administrator did not err and that we assess a 4-month penalty from the date they filed the appeal, which was June 25th, 2019. So they'd be eligible to apply for the permit 4 months from that date.
October 25th.
A second.
Have a motion, have a second. Any comment?
My only comment is, I guarantee you, he won't forget anything he's supposed to do going forward.
Yeah.
You're correct,
Yeah.
sir.
I sort of saw that.
Yeah. All right, so
I get it, too.
motion, second. All in favor, say aye, raise your hand. Good, you can apply for a permit on October 25th. Make sure you get your permit before it's listed or anything else, and you'll be good to go.
Thank you.
Sure
so
thing.
much.
All right, do we need like 3 minutes? Do we need a break?
I mean, I do, but I can hold on because there's only 2 left.
Yeah, this section's a change of ownership to lawyers.
Fine, I'm going to go to the restroom.
All right, like 3 minutes.
Sure.
I mean, just a very, very quick facility break, and then. Sure. Barely.
6205 Bosswood Drive. Mr. McBroom is here on behalf of staff. Is there anyone here in opposition to case 361? Yes. So each side will have 10 minutes. Mr. McBroom will make his presentation, and then Mr. Henry, you can make yours. Of course, reserve your time from the 10 minutes if you want to rebut anything, and then opposition can go.
Good. Thank you. Appreciate that.
A non-owner occupied short-term rental permit was issued to the property owner, Samuel B. Levine, on May the 9th of 2016. On March the 2nd of 2017, an email complaint was received for advertising and renting over in excess of the permitted occupancy. The property was cited and came into resolution of the case by correcting the advertisements on the 17th of March. July the 19th, ownership change from Samuel B. Levine to the Samuel Billet Levine Revocable Living Trust by sale of the instrument noted. Host cease and desist letter was sent on the 30th of May of 2019. On 6/17 of 2019, a renewal review and ownership change was discovered. On June the 24th, a short-term rental permit cancellation letter was sent. And on or about July the 3rd of 2019, the website advertisement was removed. On 7/3 of 19, the BZA appeal was filed. There were 17 documented stays after the ownership change. However, there were no documented stays after the cancellation letter, and the advertisement was not reposted.
Okay. Mr. Henry.
Mr. Chairman, members of the Board of Zoning Appeals, my name is Sean Henry, 315 Dedrick Street. I represent Mr. and Mrs. Samuel Levine. They reside at 6607 Ormond Drive, and they own the subject property, which is 6205 Bosswood Drive. We have handed out to you here today a folder containing 4 items. One is a timeline that largely tracks with what you just heard from Mr. McBroom. It also contains a letter, an email letter from Council Lady Mina Johnson that was received yesterday. And as of today, we received a letter from State Representative John Ray Clemens representing this area of Nashville. We've included that as well. And then finally, there's a neighborhood petition in there that's been signed by 41 signatures on the petition and then some additional letters. So we just want to be sure that you had that. And I'm going to refer to some of those letters in just a moment. Regarding the timeline here, there's an important piece regarding the change in Metro zoning law that I'll talk about here in a little bit. But well before there was a quit claim deed executed by Mr. Levine, and the issue here is his attorney transferred the property from Samuel B. Levine to Samuel B. Levine as trustee. And so that's really what's at the heart of the issue here. But back on February 2 of 2018, there was a zone change. Metro changed the zoning law to classify these non-owner occupied short-term rental permits as commercial uses. And in doing so, they relegated these to commercial districts. So at that point in time, we've got a date in time there that becomes important for the legal argument that I want to dive into. And I know it's late in the day, but I'm compelled to touch a little bit on the argument here. The short of it is, Metro is interpreting the text of the zoning code that says a permit, an STRP permit, shall not be transferred or assigned to another as equating to the transfer of property. Nowhere in the zoning text here is there a prohibition on the transfer of property. It's the permit itself that cannot be transferred to you, transferred or assigned to someone else. It's akin to a driver's license. You get a driver's license, it's got an address on it, you're not permitted to transfer your driver's license to anyone else. That's a non-transferable permit, driver license permit. It's the same concept here, and that's the way the law was written.
But don't they link it by saying, doesn't the rule also say that it's only the property owner that can have a permit? Or
so the way we've interpreted it at Codes is that you read the two provisions together. The owner has to obtain a permit, and a permit can't be transferred. So if the property ownership is transferred, the new owner has to get the permit. And then we also read that in conjunction with the state law, which says if you transfer ownership of the property, the permit is no longer valid.
Okay, I just want to review that so you can address that, because that's what we hear, and I just want to make sure you knew what was in the back of our minds, so you could hit each one of them head on.
And I am prepared to address that. But let me first explain why there was a transfer here to begin with. So their tax attorney, and we have an affidavit from their tax attorney, and that's been submitted as part of our packet. Their tax attorney points out that he created a revocable trust in the name of Mr. Levine, who is free to revoke that trust or amend that trust at his will. Mr. Levine is solely authorized to administer all the trust property as his own. The trust is a disregarded entity for federal and state tax purposes. Mr. Levine's social security number is used for the identity of the trust. Through inadvertence and mistake, the property was transferred to the trust. This is his tax attorney. In no event would Mr. Levine have been counseled to transfer said real property to the trust for estate planning purposes if at such time it were known that such a transfer could affect Mr. Levine's ability to operate said property as a short-term rental property. So the context of this situation, and Ms. Counsel Lady Johnson points out, we've got a unique circumstance here. So that's the background on why that was done. His CPA, Certified Public Accountant, also has a letter contained in this packet, and he asserts that the property is actually owned by him, Mr. Levine, and rented. The mortgage, insurance, and property taxes are paid by Mr. Levine. The utilities are in Mr. Levine's name, notwithstanding this quitclaim deed and designation as trustee, but the utilities are in his personal name. Metro Water Services classifies the property as commercial and assigns that stormwater fee based on a commercial rate. Piedmont Natural Gas, Nashville Electric Service. So those are just some background facts. Now, The text of the short-term rental permit law reads as follows. A STR permit, not property, but an STR permit shall not be transferred or assigned to another, nor shall the permit authorize any person other than the person named therein to operate a short-term rental permit on the property. The person named therein is still Samuel B. Levine. That has not changed. He owns that permit. It's the same person. He's the permittee. He's the operator of the short-term rental. He's the provider of the short-term rental. So no matter how you slice this.
But he's not the owner of the short-term rental anymore. It's the trust.
The question is the permit. Because the law doesn't say there's no reference to property in here. So
the property owner has to apply for the permit. The permit is not transferable, so once the property gets transferred to the trust has to apply.
And the permit is still in his name.
So are you saying
Samuel B. Levine.
is the property owned by the trust now?
It is.
And so
Titled.
Would you say that it would be the trust that would have to reapply, or Mr. Levine?
No, it's the permit holder. The question is who's the permit holder? The holder of the permit, not the property. Property's not referenced in here in any fashion. It's the holder of the permit that's entitled to renew the permit. That's Sam Levine. So he's entitled.
So what if Mr. I'm sorry.
Yeah, go ahead.
So if the property hadn't transferred to the revocable trust and it had transferred to me, but Mr. Levine holds the permit, could he still renew the permit even though I own the property?
So long as Mr. Levine is still the permit holder, the way this text reads, and I admit there's some ambiguity in here, particularly when you look at the Metro website, and I want to point that ambiguity out. But so long as the permittee is the same person who's authorized to operate and provide a short-term rental, the owner of the non-owner occupied property is irrelevant. The code doesn't address that at all. It's talking about the permit. So the property.
The law doesn't allow transfers of the permits.
And the permit would not be transferring because it's in Mr. Levine's name. He's simply trying to renew the permit that he's always had for 3 years.
But he's not the owner of the property anymore.
The trust is the owner of the property.
I think therein is a problem. Our hands are really tied on these because this is a question of law.
Correct.
And we've had this come up before. I appreciate it is somewhat unique, but we had, when I first started sitting on the board, we had 4 or 5 of these come up where there was a transfer to either an LLC or a trust. And we kind of hashed through all these legal issues, and I get that it seems like a gotcha, but our job is to determine whether or not they erred as a matter of law, and we have visited this issue before and determined it, and I'm ready to hear you out.
Yeah,
I'm not going to cut you short.
Well,
The transfer and what people have tried to argue is that essentially, even though there was a transfer to a trust, the person who owned the property is now the trustee, but still what the zoning administrator has determined and we have upheld is that mere transfer, it is done because it has a legal effect. There's a reason you transfer from an individual to a trustee, and that transfer meant that permit that was in the previous permit holder's name was not transferred, and then you've got a new owner of the property.
But that interpretation and application and enforcement is not grounded in the law. It's not in here. There is no black and white statement that you can't transfer the property. That's not in here. It's not in the law. And that hasn't changed, by the way. We just had a new law adopted a few weeks ago.
You mean can't transfer the property or can't transfer the permit?
There's no reference to transfer of property. That's my point. There's nowhere in this zoning law for short-term rental that says you can't transfer the property. It's not in there. If someone can find it, then I'll eat crow.
I'm with you there. You could definitely transfer the property. I could hold a permit and a piece of property. I could transfer it. That's a right But the problem is when you do that,
What's the net effect?
you have a new owner who then has to, that permit that was in place is no longer effective, and you've got a new owner who's got to reapply.
But only if that owner is not going to use the same permittee. Because the short-term rental is...
But that owner can't use the same permit because the permit's not transferable.
Exactly my point. Mr. Levine is not trying to transfer the permit at all. He hasn't.
Right.
He's not. He still owns the permit. And he's simply trying to renew the permit irrespective of the transfer of property because there's no prohibition on the transfer of property.
But he no longer owns the property. The trust owns the property.
Correct. But he owns the permit.
And so
Right.
you're saying that if because it's a renewal and not a new application, he's eligible as Mr. Levine, not the trust.
That's exactly right. Yes, sir.
To renew the permit. And so let's say, so the scenario I presented earlier, which was if he had sold it, if I was the owner and not the trust, then, I mean, it's, this is a case where you've got, where we wish the council would have a solution.
Yeah.
This, and we've had a couple where we give us a path, because it doesn't seem right, and single owner LLCs, revocable trust, that type of thing, and you really hope that legislatively they would fix this really weird situation, and so that's why if there's a different way to think about it, and there is a legal path, then that would be I'd like to hear. But if I were the owner and not Mr. Levine, but he had the permit and he renewed his permit and I went to get a permit, who has a right to the permit?
That's right.
Are you saying that's just gray and up in the air?
I'm saying it's in the name of the permittee, the person who has issued the permit.
May I ask
Right. Obviously,
Mr.
you wouldn't-
Henry a question? Mr. Henry, can I ask you, is this the vested rights?
No, I'm not there yet.
Okay, but you're
Not
going to
yet.
end up there?
Yeah,
Okay,
yes,
okay, I was
if
just
I'm-
curious. All right.
And if I may just continue to run through this legal argument. And really what we have here is ambiguity, as I think you're recognizing in all that's been in front of you. We've got some ambiguity, we've got some vagueness, and because of that, that gives you the opportunity to consider these facts, make a decision that's different than you may have previously given to another case where the facts don't match. To contribute to some of the ambiguity and vagueness and confusion, the Metro website says that a change of property ownership will result in permit cancellation, such as, quote, changing from a person to a trust or LLC or vice versa, as a result of refinancing. As a result of refinancing. There's been no refinancing here. That's not been involved. Another piece on the website, which we've attached here to our document, says that permit holders in R zone districts, which this property is, may be eligible to apply for renewals, but those permits are not transferable if the property is sold. This property has not been sold. The title has changed, but it's not been sold. So
when you say sold, you're saying a financial transaction of some sort.
Consideration exchange,
Right.
That's right. So those are just two elements that are in the website, and when you look at the law and it says nothing about transfer of property, then the website says things about transferring property, but only if it's refinancing or only if it's sold. And those things create a lot of vagueness.
I mean, stuff gets on websites that shouldn't get on websites. I don't know that I look to that as authoritative, but isn't there, and maybe I need to address this to legal counsel, I mean, doesn't the statute say that the permit has to be issued in the name of the owner of the property? Because I think what their argument is that essentially, as I understand it, is that the permit can be held by someone who doesn't legally own the property. So isn't there a statute? I'm assuming what y'all are basing your opinion on is there's a statute that clearly says, although I think Mr. Martin is saying there's ambiguity, but what is the law that requires the owner to have the permit as opposed to just anybody else that could have the permit. Do you have that statute or?
Right, I'm reading from 17-16-070.
Can you read it louder? Because not only am I far away, my hearing is.
I'm reading from 17-16-070 U1A.
Okay, is that the Metro Code? Or?
That is the Metro Code,
Okay.
because this applicant indicated that he had a not owner-occupied permit. What that section of the code says is that no person or entity shall operate an STRP or advertise a residential property for use as an STRP without the owner of the property first having obtained an STRP permit from the Codes Administration. So again, it says no person or entity shall operate an STRP or advertise a residential property for use as an STRP without the owner of the property, ergo here being the trust, having obtained an STRP permit from the Codes Administration.
And I'm not unsympathetic to your client's position. I think that they're interpreting this. To me, it's really clear that the owner, the permit has to be with the owner, and that's what they've decided is the law is. And to me, that seems like that there's no other real conclusion from that statute.
Yeah, I think the emphasis on person is important in this situation. The person's the same person. It's the same person who got the permit. It's the same person who's renewed the permit twice. It's the same person who's trying to renew the permit now. But for the transfer to a trust, he's being prevented from having that permit. Council Lady Mina Johnson has weighed in on this question because legislative intent, what was the council, speaking of what the council is trying to do, trying not to do. In her email here to this board, my intention when I co-sponsored the bill was to restore quality of life in residential neighborhoods, but not to punish STR owners who follow the regulations and cause no harm to surrounding neighbors. Sam and Lisa have been an example of how a well-managed STR can be a good neighbor, as you can see from the support from their surrounding neighbors. I believe Sam and Lisa are the victims of unusual circumstances caused by bad advice from the real estate attorney. I'll drop down. I hope the Board of Zoning Appeal Commissioners decide in favor of the Levines and reinstate their STR permit. So that legislative intent, I think, has some bearing on how you consider this request. That's the Metro law. I want to talk about state law here real quick. The Short-Term Rental Unit Act that was adopted after they renewed their permit, but before they transferred the property to the trust, I don't think is really in play here. But Representative Clemens has weighed in on this, and he says that this board is now tasked with deciphering the state's actions and intent. He actually opposed the state law. He felt like, as he says in his letter, this decision really ought to be up to local governments and not the state. But in any event, he says that there's sufficient vagueness in the law, the state law, to require examination of legislative intent. One could point to the dual purpose of the legislation, which was the proponents' objective to protect owners' property rights, and B, to prohibit the conveyance of the original owner's property rights to subsequent purchasers in perpetuity. Again, there's no purchaser here. He continues, when reviewed cumulatively, one could reasonably argue that the legislature did not intend to punish law-abiding owners or deprive them of their property rights when the owners effectively retain sole ownership of real estate, as is the situation here, as well as the benefits and responsibilities resulting therefrom, regardless of a change in legal ownership. So one of the state legislative intent representatives here is commenting on the legal ownership question relative to sole ownership of the property, which is still in the Levine. So I throw that out there just for thought. Finally, what's really important here, I think, is that setting aside the short-term rental law, and Metro's now had, I think, 7 of them. There's been about 7 amendments to the Metro law. And now we have a state law, which is even further throwing some ambiguity and question and vagueness into how these things are handled. What's very certain is that the Non-Conforming Property Rights Act, which provides for any change in zoning of affecting a commercial business, which this is, cannot prevent that business from continuing. In fact, it states that it shall be permitted. And so when Metro changed the zoning law on February 2nd of 2018, they made this use a commercial use. It was non-conforming because you can no longer do them in a residential district. And at that point in time, this short-term rental operation, a non-owner occupied short-term rental business, became legally non-conforming and permitted under state law to continue. And there's only 4 factors that my client has to meet in order to avail the protections that the non-conforming statute provides. And let me just touch on those real quick. Change in zoning law. So the zoning law clearly changed February 2. That was Council Bill 2017-608.
What statute are you referring to? Is that in our material so I can follow along with you on that?
I did not supply you with the statute, which is...
Is that the one Mr. Lawless was referring to?
Yes,
vested
it is.
rights. Okay.
Yes, it's Tennessee Code Annotated 13-7-208. I have a copy of it here. I can certainly submit it.
So are you reviewing the timeline?
Yeah, so on the timeline, there's some bold. February 2nd of 2018 is in bold, and that's what I'm referring to now. That is a bright line date for the Levines being protected under that state statute. And again, they only have to satisfy 4 facts in order to avail themselves of that. One, there's a change in zoning. That occurred on February 2nd. That affects the use of this property. Secondly, the short-term rental that was permitted, it was operating prior to the change in the law. Well, clearly it was operating for 2 years. 3, the business was operating when the zone change took effect, and it has taken effect. And then third, the current business is the same business. The current operator is the same. Nothing has changed at all pertaining to how the property was being used and operated before they quit-claimed title to himself as trustee. So for all of those reasons, we would submit that the permit was not transferred. The permit is still in the name of Samuel Levine. It will remain in the name of Samuel Levine. And we ask that you approve the renewal.
Okay, and there is opposition, I believe. We will hear from the opposition, and we'll allow them an additional 2 minutes to give you 2 minutes and 43 seconds for rebuttal if they need the extra 2 minutes, unless there's objection from the board.
You should have made Buddy come.
Yeah.
I would just respectfully request that we forget about the last case that I had and we just start anew on this one, members of the board. It's a very nuanced argument, but it's a correct argument. When you transfer legal title from an individual name to a revocable trust, that is a change of ownership. A revocable trust is a separate legal entity from an individual's name. Throughout the code, during the application and renewal requirements in the Metro Code, it says owner, 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 owner. We have eliminated non-owner occupied short-term rentals in residential zone districts in this city. This is what we have. This is I believe it's a RS40, and this is a very nice residential neighborhood that the Metro Council has fervently stated that they do not want short-term rentals in. Now, I understand, and I do sympathize with the applicants that they had a permit, and that is a valuable permit. But however, when you transfer ownership out of one entity to another, you lose that permit. The reason why you get a revocable trust is because you get a benefit with that. But many times when you receive a benefit, there's also a detriment. The benefit is that maybe you can bypass probate and save significant monies out of the probate process. The detriment is you lose your Metro short-term rental permit. And that's what we have here. As far as 137603, that's the Short-Term Rental Act. The pertinent part says until the property is sold, transferred, ceases from being used for 30 continuous months. Transferred. If you look at the quitclaim deed, which transferred the property in the individual's name to the trust. At the top in the affiance section, it says the transfer consideration. If you go to the grantor's language, it says that the party remise. Remise, if you look at Black's Law Dictionary, means to give. To give is to transfer. Black's Law Dictionary quitclaim, a document that allows the transfer of a claim, be it an interest, right, or title, that the maker of the document may have in a property. I mean, it is a transfer. And it's probably something that the council maybe needs to massage. Maybe they need to go back and rethink that. I think there's a lot of things that the council probably needs to correct to alleviate some of the burdens of this board. But the way that the law is written...
I wouldn't hold our breath on that one. So.
But the way that the law is written, the way that the code is written, and the way that the Tennessee law is written, none of that is applicable here. It was a complete change of ownership. And you have to be, it's like the very first thing, to have an owner-occupied permit in Metro Nashville, you have to be the owner of the property. Going back, I should probably tell you who I represent today. I got into my argument. I represent Mr. Tim Wilson, who lives at 610 West Mead Drive, and Mr. Kevin McGinn, who lives at 625 Jocelyn Hollow Road. So these are relatively close, neighbors that would be impacted or potentially impacted by the use of a short-term rental permit. And they want me to express their vehement opposition to allowing this short-term rental to continue in this residential district. And to the Vested Property Rights Act. I was fortunate, we argued the case at the Court of Appeals against Mr. Henry's firm on the Vested Property Act. They prevailed, but one of the reasons why they prevailed is like they had the same owner through the entire process. I don't know if that would have been the same situation if somewhere in the middle of that zone change, either before or after, they transferred ownership. Vesting occurs with the owner. The person who becomes vested with a right doesn't get to transfer that. That is the whole point of a transfer. So I'm sympathetic to their cause, and I understand that it's a very nuanced argument, but sometimes the law is very nuanced. And in this situation, I believe you can look at the Metro Code, you can look at the Short-Term Rental Act, and you can look at the Vesting Property Rights Act, and none of those affords any relief for the applicants. So I would just therefore that you would side on the neighbors that are most impacted by here or could be most impacted by it, and also continue to side with Metro Legal's interpretation of this and deny their request.
Any questions? Thank you.
There's some facts, and Mr. Henry, you have.
I don't know if there was any.
Are there any other?
Is there no one else?
I don't know if there's any time left for rebuttal.
Well,
yeah, there's 2 minutes.
Not really so much.
If you're giving him 2 minutes, that 43 seconds was over.
Oh, he was going down.
2 minutes.
Yeah.
Then, you have 2 minutes, but I have a question on
Could we? Just for the person. Could we vote on the giving them the additional?
Oh, we did.
time?
I did. I asked.
Okay.
I asked if I said
All right.
I'm allowing both sides an extra 2 minutes unless there's an objection, and there wasn't. Is that acceptable for the 2 minutes? Okay. I mean, we can make it more formal.
Well, I just want to make sure the record's clean.
Yeah, and I did. I thought I had.
Yeah,
I got at least a couple of nods, although maybe a watch look. The question I have is, if I were to make a motion that the zoning administrator did not, or the zoning administrator erred in this case, how would it sound? But tell me what that motion would be, which essentially summarizes your case, but and gets to the heart of the item A. What would a motion be that the zoning administrator erred?
You're right. So irrespective, I move that irrespective of the transfer of the property, the permit has not transferred nor been assigned to another. permit is still in the name of Sam Levine. And importantly, that section that I'm referring to, can I reread that real quick? And a STR permit shall not be transferred or assigned to another individual, person, entity, or address. No, nor shall the permit authorize any person other than the person named therein. There's only one name, it's Samuel B. Levine, and hasn't changed, to operate an STR permit on the property.
Okay. And now you can.
Hi, thank you for your time. I'm Lisa Levine. No offense to all the attorneys in the room, but it's an attorney that got us where we are today. The gentleman, we've only been married 3 years. We went to have some estate planning done. Thought we went to see a good attorney, and he told us that to protect my husband's property for his children in the long run, that we should put the property in a trust. Never used the word transfer. In fact, the word he used was fund. We both have copious notes where we ask that attorney, is there anything that you're telling us that's going to hurt us? We have a short-term rental. We've had it for a couple of years. Our neighbors are happy with us. We want to continue to do this for several more years, and then we want to move back into that property. We don't want to do anything that's going to hamper that. Can you guarantee us that this is no problem? And he told us, and I quote, it's a lateral move. It's not going to hurt you. You need to let me go ahead and do it. So we trusted an attorney. We trusted a professional, and we let him do what he said was going to be okay. And we thought it was okay.
Our time's up. Are there any other questions?
I have just want to pose a question to Mr. Henry, if I can. It's just a legal title, if there's a mortgage on the property, is technically held by the trustee under that deed of trust, isn't it?
I don't know the
No,
answer.
I'm just posing a hypothetical question to you, just because I'll bring it back into your argument in just a second, if you can. I mean, legal title. This is Black's Law Dictionary. This is Hornbook stuff that you and I probably had more years ago than we want to talk about. But legal title is technically vested in that trustee under a deed of trust, and this is a deed of trust statement. Let's just use that as a given, if you would, please. Not the owner of the property, because the person who borrows the money and places that deed of trust on that is the equitable owner. They own the equity in that property. The trustee under the deed of trust is the legal owner under Tennessee case law. So if, in using your argument with the transfer into the irrevocable trust, if you use that argument, if someone, say, has a permit and goes out and refinances their home that they're using, that they hold the permit, and they have a new deed of trust on that property, the legal owner's changed. So everybody that does that wouldn't be subject to short-term rental regulation, which is a proper exercise of authority by the state and by the Metro. So they wouldn't be eligible since they've transferred ownership of the property, would they?
That's correct.
So what is the difference in this instance, which is a roundabout way of getting to where I think you were a little bit ago? What's the difference if you transfer it to a legal entity, an irrevocable trust, as the Levines did, based on, I don't know the background of the legal advice that they got from their estate attorney. If that's the case, then maybe the gravamen isn't necessarily with the short-term rental and whether they're eligible or whether the zoning administrator made the correct decision, which I think he did this instance. What is their right or their regress, and that would be the attorney that gave them the bad advice. Because their attorney wasn't knowledgeable of the laws involving short-term rentals. So you're asking us to disregard what our charge is, and it's a good argument. I mean, I like your argument, and we've argued about this before years gone by. But I'm having a hard time getting there because it is a transfer into a separate legal entity, and I don't think scheme and at least I'm going to be voting that way, the scheme that we have, the permit's not held by the individual per se. You've got to have an ownership interest in the property to have short-term rental, don't you?
Initially, yes.
Yeah, but
Initially.
what is the whole subject matter of a short-term rental? Are you renting a car? No, you're renting a house. You're renting a dwelling, or you're renting a room, or whatever.
Right.
So to extrapolate your theory, which is a good one, I mean, in hypotheticals, I think you got the statute because you make it unenforceable. You make it an impossibility in the totality, and that's just I'm explaining what and why I'm going to rule the way I am, or I'm going to say what I'm going to say when we get to that point, so that you'll know where I'm coming from. I mean, it's a good argument. I like your argument. I just don't think it holds water this time.
And I don't have any evidence of a deed of trust existing on this property.
Oh yeah, it's not them subject. I mean, I'm using that as a universal term, not necessarily as to Levine's. They probably don't even have one. Don't care.
And what we do have, though, we do have a mortgage. There is a mortgage on the property. We have a mortgage statement in the record here, and it's addressed to Samuel B. Levine at his home address for the property in question. So consistently across the board, every document, private sector document, public sector document, it's all addressed to Mr. Samuel B. Levine. There are companies that are obtaining short-term rental permits for non-owner occupied property. Companies. They don't own the property. They're short-term rental providers. They are management companies. The state of Tennessee.
But that's really, and I get what you're saying, but that's really a policy argument. I mean, that's a policy argument. And,
Can I just say, as somebody
Well,
that's worked really hard,
Yeah, ma'am, I appreciate it, but you guys are out of time. If somebody can ask a question, but it's only question and answers, and I get it, and I know you.
I was going to ask you a question. I'm sorry.
Oh, well, I don't know if I know the answer.
Probably the smartest one of all of us.
And this isn't sadly, it's not a question and answer scenario, and it is a hard situation. And I did realize that that you actually spoke after in the rebuttal period without speaking in the beginning, and I need to ask the opposition if there was anything specific that she said that you felt like you needed to address.
There's one thing that I would, and I'll be very quick, Mr. Chairman. I know it's late.
I think just but yeah, if in 30 seconds you can, if there's any one specific thing that Ms. Levine said that you want to point out to, and then.
no lawyer can say anything in 30 seconds. So
It's late. We got one more case, and that's all you got.
We get paid by.
But just because of the rules, if you don't speak early, you can't speak later, and I allowed that, and you should have a chance to at least say so.
And I'll be brief because if you look at the code, the owner has all these.
I mean, I'm talking about specifically to what Mrs. Levine
she did,
said.
because she said something about the trust and going to her children. I think that's very important because, like, a trust very well may remain once the property has been given to the beneficiaries. So we have a situation if we go with the argument that the permit just continues without any transfer with the ownership, we could very well have a whole new set of owners down the line operating under the same permit.
But if the trust had gotten the permit at the very beginning, then that would happen anyway.
Well, that would be, but that's not the situation.
But you're saying that
here.
this adds an additional benefit.
It just adds an additional benefit to it and just identifies the significance of the transfer.
Okay, thank you. If there are no other questions, we'll close the public hearing. But that's up to us at this point. The public hearing is closed. Thought?
Well, I think Mr. Martin did as good a job as he could do with what he has, and I think if we were here to decide this on a policy, is it fair to these folks? If this turns out this way, then we might all be moving in a different direction. But our job in this is very, very limited, and that's to determine whether or not the zoning administrator erred. And I think that it's clear to me the zoning administrator didn't. There was a transfer. The transfer has legal effect, and our code says that the owner has to apply for and obtain the permit, and so I don't believe the zoning administrator erred.
I'm eager to find a path that would allow me to decide otherwise in cases of single-member LLCs and trusts of this nature, because I think that it is an area of the law that probably was not intended by council, but I'm not a council member and I didn't vote on it, so I can't say. It's why I was pushing for a path. I do think that there's a lot of gray. I do think that Mr. Henry has raised gray areas that maybe somebody else needs to decide besides us if they're there. But I know that the code staff has been consistent in how they applied, how they've interpreted the rule, and it puts us in a really tough spot in cases like this. The answer may be clear, but it's not a pleasant situation. Is there? I mean, I've got three lawyers and 2 of us that aren't.
Remember, my malpractice carrier doesn't cover this.
Is there a path
It's the amount of
that you
time.
see for an error in the determination on the case?
Boy, it got quiet.
And even,
I think it's just when is the effect?
is there a motion
Motion to uphold.
that the zoning administrator did not err?
Did not err.
I'll second that.
Have a motion, have a second. Any other discussion? All in favor, say aye and raise your
Aye.
hand.
Aye.
No?
The vote is
I
on.
haven't voted.
Okay.
We're short.
Well, I'm gonna vote no, but the fact is it doesn't have 4 votes and is not gonna pass. So it is held in votes 3-2.
So let me be clear. How did that vote turn out?
It means that
Mr. Lawson's
the vote was
motion was
3-2 to uphold the zoning administrator. It would take 4 votes to overturn this, and so it's essentially the zoning administrator.
It'll stay open on the next.
I thought there were 4 votes to uphold the zoning administrator. Maybe I missed.
No, I didn't vote.
You just
I
didn't
voted.
vote.
I voted no with. Yeah.
Okay.
So it's
you
3-2,
voted
so
no.
that means that this will
3-2.
stay open on the next docket, and Ms. Chappell and Ms. Sanford will have an opportunity to watch the video and vote, so that. And
So
we
it comes
can-
back again.
But the public hearing's closed.
Public
They'll
hearing's
just
closed,
watch.
so we won't hear.
Yeah.
We won't hear the case again.
That's right.
I think it's worthy of the 2 other attorneys on the board to hear the case, if they so choose to.
All right. So
Awesome.
this will be back on the docket on September 19th for another vote. But no public hearing. Last case is case 2019-362 involving property at 786 First Avenue North. I don't see anyone else in the room. Were you here in opposition or to this one too? Are you? No. Okay. So we just have the appellant. Mr. McBroom will make the presentation for staff, and then the appellant will have 5 minutes to make your presentation.
On April 26th of 2018, a non-owner occupied short-term rental permit was issued to the property owner, the Hidden Gem. On September the 12th of 2018, an ownership change from the Hidden Gem to West Iris Realty LLC by the sale instrument that is noted canceled the permit. There were 10 documented stays after the ownership change between 9/12/18 and 4/26/19. 4/26/19, the permit was set to expire and was not renewed. However, it had already previously been canceled due to the ownership change. On May the 30th of 2019, the host cease and desist letter was sent. Estimated delivery on 6/6/19. May 19th, we had 2 documented stays. June of 2019, we had 1 documented stay. July, 1 documented stay. BZA appeal filed on July the 3rd of 2019. July 9th, advertisements removed. Advertisements were reposted on the 25th of July, but based upon my experience, I would say it was probably done by the website because there have been no subsequent stays and there are no documented complaints against this property.
right, state your name, address, and tell us what happened.
My name is Ilya Tashinsky. I live in Franklin, 1420 Willowbrook Circle, Franklin, Tennessee. I had this property for a couple of years. Originally, we set up LLC called Hidden Gem. Last September, I was working on a real estate deal, and I had to bring the property as a part of my down payment, and my bank made me change it to West Iris LLC. It was completely my fault. I did not know about the law that I had to reapply for a permit, and I failed to communicate this to my property manager. So I did not receive any communication from Metro, so we continued operating this short-term rental. We paid all the taxes. I have everything on record that everything's been paid. My property manager went in, I believe it was middle of June, to renew the permit, and that's when we found all this out, that we were doing it illegally. So immediately we removed all of the advertisement and canceled all the bookings. In July, we were told that we could at least try to advertise it for stays that are more than 30 days. So that was not constitute. It was not a short-term rental. We actually didn't get any bookings, but that's what I believe what was showed up on the website, that we were trying to rent it for more than 30 days. It's completely my fault. I was not informed, and I'm not going to make any excuses. I'm just, I would like for you to know it was not intentional. I was not trying to do it illegally.
What was the last day that you rented the property?
I believe I don't manage it myself. I have a management company. I think it was in June.
Okay.
That should have been the last time.
Okay. Any questions?
Well, is it still are you still trying to apply for a non-owner occupied permit?
Yes, from what I understand, I have to do it under my new LLC as a West Iris LLC. It should be on the permit.
It's in the downtown?
Yeah, it is.
So I mean, eligibility is something that we're not, we don't really consider. I mean, he may be eligible. He probably is. If he's not, then we can still say we can go apply, and they can tell you whether you're eligible. But then I don't include.
So that makes it different from the prior one because of the
Yeah.
zoning.
Yeah.
Yeah, exactly.
And they wanted to renew it, the old one. He just wants to apply under his new business name.
Yeah.
So,
From what I understand, that's the right way.
Right.
Now it's owned by a different LLC. I have to
right.
start over.
Any other questions? Do you have anything else to add?
No, sir.
Okay, we'll close the public hearing. Looks like we've had people that have listed the property before for more than 30 days, and it's shown up as the ad going up. I'll take him at his word on that's what happened. Say the zoning administrator didn't err. He's eligible to apply 4 months after June 15th, which would be October 15th.
I second that.
Have a motion, have a second. Any discussion? All in favor say aye. Aye. Any opposed? That passes. You voted for it?
Yes.
Passes for
I
it?
did too, yeah.
I voted for it too. I was just.
Okay, you voted
mine was
for it.
delayed.
We get
All right.
quiet.
It's unanimous.
You can apply for a permit on October 15th, but make sure it's not listed, rented, or anything else till you get your permit.
Thank you guys for your
Sure
time.
thing. We're adjourned.
Thank you.
And I think you're right, but when I have a vote,